Very good. Mr. Barazia, are you ready to continue with your evidence?
Yes, Your Honor.
Thank you very much. You're under oath still, you understand? Or affirmation, I should say, but same thing.
Before the questioning starts, Mr. Barazia, can I just check that you've turned off all your devices again?
Yes, all turned off.
Thank you.
Mr. Barazzi, you gave some evidence yesterday about the fact that there'd been a new managing director for real estate appointed and that you had started to take a more limited role. Can you remember when it is that you started to step away?
I can't remember the exact time.
Okay. Can you tell us what the impact was of you stepping away? Does that mean you were no longer involved in decisions and were merely consulted on occasion? Or does it mean you washed your hands of all of the dealings with Hexagon?
No, I was still consulted and involved when it came to critical decision making, but away from the day-to-day.
Okay. And critical decision making would have included things like the mix and the GFA?
Yes.
Okay. Could you please be shown 1379? That's F1379. So you'll see here, it's a letter of the 28th of October from Mr. Nadar.
Okay.
Now, were you involved in the decision to finally reconfirm the 1.75 million square feet GFA?
I mean, I don't recall specifically, to be honest, but like I said yesterday, we signed an agreement and we were planning to honor it.
Okay. Can you explain why there was this period of time over months when the DIFC appeared to renege on that agreement, go for a smaller amount, and then finally come back and confirm the higher amount?
I don't think it was reneging. It was just a junior employee trying to be, or just being a lousy bureaucrat, if you ask me.
Okay. You appreciate it's not particularly satisfactory for Hexagon to be trying to develop a major plot of land and having such a key input into the process change because of lousy bureaucracy.
I didn't say lousy bureaucracy. I said a lousy bureaucrat. There's a big difference.
Okay. But leave aside for a moment whether it was a lousy bureaucrat or lousy bureaucracy. You agree that for a counterparty who expects good faith and best endeavors, that doesn't come close to either of those.
But I believe in the whole scheme of things. By then, the foundations should have started, to be honest. So a couple of months delay because of a junior employee, I don't think was the detrimental thing about this project. The detrimental thing about this project is that the partner did not have funds and did not manage such a project with such a scale before. This was my humble view back then, and still is.
Okay, you understand that both those humble opinions of yours are heavily disputed. I won't cross swords with you on that because it's there are other witnesses in this case that address it. But going back to this junior employee for a couple of months, you agree that it's arbitrary, isn't it? If you've got in writing 1.75 million square foot, and then you're told actually it's less than that, and then ultimately, eventually, you're told, oops, we had it wrong, and it's down to a junior employee getting it wrong. That is arbitrary treatment, isn't it, of Hexagon?
If that is your view, it's your view. I don't see it.
I'm interested. The judge doesn't care about my views. He cares about your evidence. So what's your take on that? Do you agree it's arbitrary?
Can you define exactly what you mean by arbitrary?
Unpredictable,
Just
illogical. Unpredictable, illogical.
Could have been, but to be honest, I don't know what was that employee thinking.
Okay. Well, tell me this. You said a junior employee. Mr. Al-Najjar is Director of Project and Asset Management. He doesn't strike me as a junior employee. Would you agree that he's probably a little bit more than junior? He's not senior management like you, but he has a responsible position within the DIFC.
I wasn't referring to Mr. Al-Najjar.
Who were you referring to then?
The letter that was sent by the gentleman, what was his name? Al-Musa, last name Al-Musa.
Okay. You're not suggesting he was acting alone. It certainly seems that his position was endorsed by his superiors in the engineering department.
I don't know. I don't see him copying anyone on that letter or email.
Okay. All right.
Or I didn't see him. I didn't see it today. So
did you admonish the junior employee in question for his conduct and apologize to Hexagon for the misunderstanding, if that's what it was?
I wasn't his boss. He had a boss.
Okay. Did you ask his boss to?
Why would I ask his boss?
I don't know, Mr. Barazari. It seems to me you're the senior key person on this project, and something pretty significant has gone wrong. I'm just wondering whether you took any responsibility for that and sought to ensure that it didn't occur again.
Well, it's Mr. Barazi, just to.
Oh, my apologies.
No worries.
My sincere apologies.
Yeah. So I would, again, I don't remember exact events, but one would conclude that this letter dated 28th of February came as a result of the mess that the junior employee created.
Okay. All right. And I want to turn back to mixed use. You may recall we had some questions and answers yesterday about the mixed use. And I think where you got to is you felt that 88% was too much and you wouldn't be able to get that approval, that 34% as per the master plan guidelines was probably a little low, and I think your number was around 60%. Have I understood your evidence yesterday correctly?
Well, I didn't feel that 88% was too much. It was impossible. Not a feeling that, I woke up in the morning and I felt, no, 88% is too much. There's a science behind it. Okay. So just to be specific on the description. And yes, I, again, out of sympathy with the partners, I endorsed increasing the office space to the best extent possible, technically, that the master plan can absorb.
Okay.
And again, I'm not a technical person. This was a back and forth discussion with Mr. Najjar, with the TCOM zoning department, which was responsible to issue the building permits and all of that.
Okay. Now, again, I want to be sure that I've read the transcript correctly and understood your evidence from yesterday. By around September, when we had the concept, pre-design concept meeting, you'd reached the view that something around 60% commercial, in other words, offices, was appropriate rather than 88% and rather than 34%. Is that right?
Based on the interactions with the technical team, yes. Give or take, don't quote me on the 60%, but yeah.
Okay, we'll put approximately before the 60, shall we, to make it accurate? That's a question.
Yeah, I would say.
Okay. And You mentioned Mr. Najjar and the team. Did you discuss that with them in or around the pre-concept meeting in September?
I mean, we always have discussions. I don't know. I can't remember the exact sequence of events, to be honest.
Well, take up, will you please, 1417 in the F bundle. Now, this mixed use issue has now been alive and kicking since probably the middle of 2007, and there has been the issues with respect to the alleged agreement with you and back and forth in the emails that we've seen, and then there's the pre-concept meeting, and then Hexagon requests on 10 November the change in mixed use, and it's rejected on the 24th of December 2008 in this letter by Mr. Najjar. What I want to ask you is, given that this was a formal request and given that this was a formal rejection, there must have been, based on your evidence yesterday, some pretty detailed internal documents within the DIFC working out this issue and coming to a conclusion. Is that fair?
It could have been the case, yes.
And those internal documents would have rationalized as to why the mix that was being requested was still being rejected.
No, I didn't say that. I said the internal communications were back and forth with the technical team on potentially changing the use mix. The mix. Yeah, the use mix.
Okay. So those,
not this specific document.
Understood, but I take it the important decision here on the use, on rejecting the increase, wouldn't have been arbitrary. It would have been carefully considered, and there would have been internal communications between you and the engineering department.
Look, it's very simple, right? You are asking, they were asking almost to triple the amount of commercial space. It was an illogical and unreasonable request. As simple as that. It didn't need internal communications. It was way off mark. You know, if you ask me, if I was Mohammed al-Najjar, I wouldn't even have debated. It was so off mark, the request. It wasn't even, you know, considerable.
Tell me, Mr. Najjar was listed as a potential witness in this case. Do you know where he is today? Have you had any discussions with him about this case and these issues?
Mr. Who, sorry?
Mohammed al-Najjar.
Okay. Do I know what, sorry?
Have you spoken to him recently? Have you spoken to him about this case, or are you giving evidence or any of the issues?
No.
Okay.
Last time I've seen him probably 18 months ago, casually bumping into each other in the DIFC. We said hi, and that was it.
Okay. So to your best of your knowledge, he still lives in Dubai?
Yes, I haven't heard otherwise. Okay. He's a UAE national, so.
Okay. All right. Take up, please, 1453. Ought to be in the same bundle. Now, two things here. First, we see that the mix of 66% office, 29% residential, and 5% retail was approved by Mr. George during a meeting on the 25th of March. What's happened between the rejection in December and this point in March within the DIFC that's caused the change of heart?
No, like I said, their request for 88% commercial space was unreasonable. 34% in the context of, you know, those days would have not allowed them probably to make some decent returns on their investment. So if my memory does not fail me, we had meetings with the technical team, Turner, decom zoning authorities, several occasions, to try and what is the maximum we can allow them to have. That with the master plan would be able to absorb.
Okay, that to me, and I'm not like you, I'm not a technical person, but it doesn't seem to me to be rocket science in the sense that the parameters that you've just described are something that could be considered quite swiftly within the DIFC, and a conclusion reached quickly that 66% is the right balance between 34 and 88. Is that a fair proposition? Do you agree with it?
No, I'm afraid I would disagree. It's not as simple as that.
Okay. Well, why don't you unpack it for us and explain why it's not that simple?
So when you develop a master plan, in my humble technical knowledge, based on experience and exposure, is you would consider several factors. You have what you call traffic impact. Okay. So naturally, office space will require or will cause more traffic in and out of any development. You will have an impact on district cooling, i.e. The cooling requirements, or what we call commonly in Dubai chilled water requirement or load. It will impact power requirements, i.e. electricity, and it will impact sewage and drainage. In the context of commercial offices, obviously sewage, you have more frequent usage, for example, of the bathrooms. I'm trying to simplify it in non-technical words. So all of these factors, and obviously the biggest impact is parking requirements.
I understand. So they're the factors, but you have all of the resources of the DIFC and all of the expertise, and you have already all of the work that's gone into the master plan. You have the proposals from Hexagon. It seems to me, even considering those factors, it's not going to take long in terms of analysis of those to come up with this 66%. I mean, this is an issue that's been alive since the summer of 2007.
It does take time, unfortunately, one. Two, back then, honestly speaking, this was being done as a favor to the partner. The agreement never stipulated that. We had no obligation whatsoever to accommodate such requests. It was all out of being sympathetic to the fact that, we have this case in our lap, we need to deal with it and move on. So the technical guys, the engineering teams will always oppose any change in the master plan. It's their second nature. They're engineers. They develop something, it's like cast in stone, don't touch it.
Okay.
So it was a big internal discussion as well.
Big internal discussion. All right. I'm going to ask you just to be a bit more focused in terms of your evidence on this point. I understand what you say about engineers not wanting to shift from the master plan. I understand what you say about the favor to the partner. That's understood. But where the decision is, we're going to do the partner a favor, we're going to increase it from 34%, and it's not going to be 88%. What should it be? That analysis, that consideration, surely is something that would take a week of hard work amongst the engineers to sit down, noodle through all of the factors you've listed and say, we can do it at 66% given everything else. Do you agree with that?
No, I disagree with that. It's not as simple. And I said that before.
All right. And the 2016 master plan has up to 97% for office space. Do you know why there was such an advance on that from the old master plan, the 2005?
I don't recall those numbers, but I recall revisiting the office space component, given that we had a massive waiting list back then.
All right. Well, can you go down the page, please? Just one page to 1454. You'll see here that the agreement as to the mixed use is memorialized in paragraph 1.
Well, I think the dates are wrong in the memo, but anyway.
Now, here you'll see that there's discussion of the SPA and the process of transferring the title deeds to the joint venture is to start immediately.
Okay.
And then the affection plan is to be issued at once. Why hadn't the DIFC advanced 2 and 3 in the meantime while the mixed use was being discussed?
I mean, I don't remember, to be honest, at this stage.
Okay. Is it the case that the DIFC thought until the mixed use is resolved, we're not going to move ahead with the share purchase agreement, the setting up of the joint venture company and the transfer of the land?
Not really, because even if it would have definitely helped, but the use mix, will not be in the shareholder agreement.
Okay.
It's a regulatory thing.
If you go back, if you will, please, to 1453, the page before, you'll see this is Mr. Gemma reporting to his principals about progress, and he's saying that he's spoken to Mr. Al-Najjar twice about the affection plan. And the first time he said he hasn't got any feedback from his management, and the second time said the affection plan is just waiting Dr. Omar's signature. Is it right that things took a long time to get approved by Dr. Omar, that he wasn't particularly quick in giving decisions or approving things? And the context to consider in giving your answer is this, that the affection plan has been something that's has arisen between the parties some months ago. It's been agreed that the DIFC would be the best party to pursue the position on that, given its superior standing. And here's at least 2 chase-ups for it. So tell us about Dr. Omar in terms of his administrative prowess and approving things.
Well, in my experience, if everything was in order and in place, it's a maximum turnaround of 3 to 4 days in his office.
Okay.
1, 2, I don't believe the affection plan issue was specific to this plot. All of that side of the IFC, which is, if I give my back to Dubai, the left side, or which is, if I'm facing south, on my left-hand side, that side of the IFC was all of it being impacted by the plans of RTA. So issuing the affection plan was not only an internal matter within the DIFC. You had the land department involved, obviously the RTA requirements, and if I remember well, I flipped the page to 1455, which is the affection plan.
Yeah.
If you look at the issuance date, it was 16th of March. So in this specific case about affection plans, Dr. Omar was, a mere mechanic. He had no technical capability to say yes or no on this, right? If he got a recommendation, sign off from the land department or all the relevant authorities, internal and external, he would sign it.
Okay, so you've when you say the date, which date are you looking at there?
At the bottom, you have the reference number. Sorry, that's
Yes.
the reference number, and then you have the date.
Yeah, the date is
7th of April.
2009. Yes.
Yeah.
So you say within 3 or 4 days of that, he would have approved it?
Normally, I wouldn't say on this specific case. I'm saying normally his turnaround time for approving anything would be 3 to 4 days, if my memory does not fail me.
Okay. Well, just while you're on that document, go to the one underneath, 1456. Here you'll see that Mr. Mehta is communicating with Mr. Farouz regarding the DIFC incorporating of the new co, and he's setting forth a laundry list of requirements there. Tell me whether you agree with this. The DIFC is not like the Cayman Islands or Jersey or the BVI. It's not a offshore company's jurisdiction, is it, where you can get an off-the-shelf company or just incorporate an SPV? It's more exacting in that sense. Is that consistent with your knowledge and experience?
Yes, of course. There was a process involved.
Yeah, and that's because the DIFC, no disrespect to the Cayman Islands or the BVI, didn't want to be an offshore company's jurisdiction.
Correct.
Okay. Now, were you involved, if you go down down to 1457, there seems to be here a draft articles of association. Were you involved in the discussions that took place between the parties in relation to these documents?
Maybe, I can't remember, to be honest.
Okay, you can't remember. So, all right, we'll go. If you look at 1456, Mr. Mehta refers to, it's an email of the 31st of March, and he's referring to a telephone and confirming a meeting at 4:30 to discuss the open issues. Do you remember attending a meeting with those two regarding next steps?
I don't remember, no.
Okay. All right. You'll see, and I'll just want you to take up please just take up page 1478 in that same bundle. You'll see it's an incorporation certificate for Concept Holdings. That's on that page. Then there's application for incorporation of a company by limited shares. That's 1479. And then skip ahead, please, just a little, and you'll see 1488, passport for Suleiman Al-Majid. This, I'm just showing you some examples of what was provided. These are documents that appear to have been provided by Hexagon and CHL for the incorporation. Do you remember reviewing those or having due diligence done on those for the purposes of incorporating the company?
I was not involved in the company's registrar.
Okay. Who would have been responsible for that within the DIFC at the time?
There was a registrar of companies. It was like a department.
Okay. And well, perhaps this will maybe remind you. Look at 1491. you'll see here's Mr. Mehta, and he's writing to two people, Mr. Farouz and Mr. Youssef. Do you recognize those names and their position within the DIFC?
Sorry, 1 second. This is 1491
Yes, email of the 8th of April 2009.
from Ashish to Hafiz Fayrouz and Jinan Youssef. Articles. Yeah, Hafiz was in the legal team supporting Dean Faris.
And Mr. Youssef?
Jinan, Miss Youssef.
My
She
apologies.
was,
to
I think
Mr.
she was
Youssef.
part of the company's registry. I can't remember.
When you say companies registry, you mean the DIFC companies register, or?
Yes,
Okay, so she's not employed by the DIFC legal department. She's within the company registrar's office in the DIFC. So separate group, separate department. Okay. And to your knowledge, did the two of them, so that's Ms. Youssef and Mr. Farouz, did they work closely together on company and corporation issues?
I don't even remember Miss Youssef, to be honest. Who
Okay.
she was.
I don't know if it's the case during your time. Certainly presently, it's the registrar's office, so the Register of Companies office, and the DIFC legal office. They're on the same floor in the same building.
Correct.
Was that the time? Was that also the case during your time?
Yes, correct.
Okay. All right. So could you please go to page 14513 of that document?
14.
Oh, actually, since you're there, just have a look at 1494. I think I know the answer, but I just want to check. There's some markup in this draft in light blue. Do you have any idea whether those are changes that your colleagues within the DIFC put in, that we've just looked at, Mr. Farouz?
I can't remember, to be honest. I don't know. But normally, when you have track changes, it should show who was doing the tracking, no?
Yes. I haven't been able to find it from this document, but just wanted to check with you. All right. Well, go on, please, to page F1513.
5-1?
Yeah, so it's 1513.
1513.
So perhaps read the whole document and I'll have some questions for you.
Okay.
Now, I'm curious as to why, given the communications that we've just seen where the mix was confirmed, why Engineer Najjar seems to be changing things again. He's saying he's received no direction to change the mix shown on the master plan, so he's back to 34%. Why is that? Why is this again chopping and changing on the mix?
It's not changing the mix. This is a pure technical matter. In my view, reading this now after such a long time, basically, the IFC agreed to change the mix to the mentioned percentages, 66% and whatever. Now, it is a long process to go back, because who used to manage the zoning, are you familiar with the term zoning?
Unfortunately, yes.
Yes. So the zoning was handled or outsourced, so we don't end up with our zoning department. It was outsourced to TCOM back then, which was one of the largest government-related developers in the Emirate of Dubai. So yes, we agreed commercially to change the mix, but to go back and change all the documentation for TCOM to have the authority to change the master plan, that would have been a process. This is how I read this. This does not mean we negated again on the mix.
Okay.
What this would have meant, probably on a practical side, that had they went to issue a construction permit from TCOM, TCOM would say, no, wait, you have these deviations. They would have expected agreement from us on the deviation, right? An official communication from the IFC to TCOM allowing those deviations.
Okay. So your interpretation is that when he says, Mr. Najjar informed me that he had received no direction to change the mix shown on the master plan, that's not him changing his mind again on the mix. He's simply saying he had no direction to try and change it on the TCOM produced document.
On the master plan documentation itself, you know, the master plan has everything in it for every plot.
Understood. Okay. Thank you. But that's is that your interpretation of those words looking at them now, or is it your evidence as to what was happening at the time?
If my memory does not fail me, for example, when Al-Fattan changed his requirements from a mixed use between residential and office to all offices, he reduced the number of floors. We went through the same thing with TCOM. We gave them consent, and all of that was properly documented. The master plan itself was not reflected, updated per se.
Okay, all right. You'll see there, having read this in the third and third paragraphs down. Oh, sorry, the third and the fifth paragraph. There's chasing up about the joint venture and joint venture company. It doesn't say company, it says the joint venture, but it seems that it's clear it's about the joint venture company and the SPA and the transfer of title. This is now mid-May. Do you have any explanation or evidence to give as to why the DIFC was delaying on these things and Hexagon was having to chase?
No.
Okay. All right. And this when I look at all of the communications during your time, you're copied in on quite a few. From this point onwards, you seem to have, this is May 2009, you seem to have an even more limited involvement. What was the status as at May 2009? Were you almost entirely out of this transaction and dealing with it?
You can say yes.
Well, I don't want to say yes. I want your evidence or your memory of things.
No, I did resign at some point in time during the month of May, maybe towards the second half.
Okay.
I served notice basically.
So you're saying from May 2009 onwards, thereabouts, you were serving out notice?
Well, my resignation was not accepted immediately, but I had other key focus areas to spend my time on. I was asked to stay till the year end, which I did. I agreed to do.
Okay. Well, then I think just have a look at one last document for me then on this topic. If you go to 1525. you'll see there's a memo to Dr. Omar from Mr. Al-Najjar, 24 June 2009. Was that a memo that you had involvement with in terms of preparation?
Well, I signed it.
Yes, but I'm sure busy men like you sign a lot of things that you're not necessarily involved in the drafting of.
I mean, I wasn't probably involved in the actual drafting of the words, but I was involved, obviously, to reach the recommended use mix.
Okay, have a look here at paragraph 1. It says, as per the investment memorandum dated 18 February 2008. Do you know what that document is?
Yeah, I remember we submitted something to the investment committee.
Okay, relating to this block in February 2008.
Most probably. I don't recall the memo itself, but I wouldn't be surprised that that was the case.
Okay. All right, and in terms of the technical, this decision to go from 34% officers to 66% officers, you see under the heading technical implications, there's 3 bullets: parking power and chilled water. Do you agree that those are the, and it seems consistent with your earlier evidence, those are the parameters, those are the things that have been considered by the technical team in terms of deciding where to sit between 34% and 88%?
For the most part, yes.
Yeah, okay. All right. Go to 1546. Actually, it's probably more helpful if you start at 1544. Now, this is in September. Where are you up to in terms of your serving notice by September 2009?
Just to be precise, for the record, I did submit my resignation sometime in May. I was asked to stay till end of December. So it wasn't per se serving notice as in the term of my notice period.
Okay. Were you working as hard as you were prior to May 2009 and as heavily involved? Yes or no?
Yes, actually much harder than all the previous years.
Bad luck, not a good state of affairs. Well, tell me this, will you have a look at this? This is from Mr. Al-Fadel to Mr. Ferouz, and he's talking about a meeting at the DIFC where there were some mutual agreements regarding important issues. And then he says, I appreciate receiving your comments and confirmation on the contents of the brief minutes. And you don't need to read them all unless you want to, but there's discussions about capital and how it will be divided. There are issues about an escrow account locally for funds to be put in for the project. And there's also assurances about a project design model, and finally about rights of the DIFC stepping in. Were you either familiar with that meeting or with the discussion about those issues?
I don't remember, no.
Okay. So that means you don't remember talking to Mr. Ferouz post this meeting about these issues?
I don't remember, to be honest.
Okay.
I know the capital was always a discussion, the capital of the company. Because even yesterday when we were going through some of the papers in the previous bundles, there was track changes on the paid up capital and how much CHL would have to put, etc.
Okay. Well, given the answer you've given, you probably can't help me, but let's just check. 1546. Mr. Farouz responds, and as I read that, it's not a particularly helpful email in that it says much ado about nothing, other than I will review and management are always in charge. Read it if you will. But that response from Mr. Farouz to basically say we need to speak to management, was that something, were you privy to that or engaged?
Not to my recollection, no.
Okay. So only Mr. Farouz could help us with that.
Probably.
Yeah. All right. Now, I just want to be clear with you on this. I'm not going to be controversial about this and say whose fault it is. There's plenty of contemporaneous documents here, and the judge has the benefit of a number of witnesses. So I'm going to ask you this just as facts as to whether the chronology of events leads to these conclusions. You agree by this point in time, September 2009, there's no concept design because Perkins have been terminated.
I can't remember, to be honest.
Do you remember that with Perkins, they had the two towers, but they couldn't get the efficiency to a level that was acceptable for the DIFC or Hexagon?
Yeah, that rings the bell, yes.
Yeah, and they were terminated as a result. You need to say yes or no.
I can't remember. I remember the efficiency issue. That I do remember.
Mm-hmm. Do you remember Perkins being terminated when they still couldn't come up with an acceptable efficiency?
I don't remember, to be honest.
Okay. And at this point in time, the mix and the GFA have been finally agreed.
Correct.
But there is no SPA and no joint venture company has been incorporated and no land has been transferred.
Not to my knowledge.
Okay. And certainly, if we just look at all of the communications we've seen culminating in this one, certainly Hexagon are continuing to press for those things to be done.
I mean, if you read these documents in abstract of other communications, yes.
Okay, thank you. Subject to just checking with my colleagues, my lord, I don't think I have any more questions, but if I could just have 20 seconds.
Yes.
Yes, thank you very much for your time and patience, sir. And my lord, no further questions from the claimant.
Thank you very much. Any re-examination?
No, my lord.
Thank you very much, Mr. Barazi. There's all the questions. You're free to go. Thank you.
Thank you very much, Your Honor. Thank you, gents.
My lord, we may just need a few minutes, up to 5 minutes, to switch the witnesses around. Ms. Gallerese is here and ready, but Mr. Barazi is going to need a little bit of time to get himself out of the room, and if we just take 5 minutes, then that should be sufficient.
Well, happy. I mean, if it's okay with your lordship, I'm happy for us to just take the break now.
Whatever makes most sense, really.
Yeah, let's do that. If we were to come back at say 10 past, then that would be an hour and a half till 11:40, and then wouldn't muck up the schedule for the rest of the day too much.
10 past is being a little generous, isn't it? Almost 20
yes,
minutes.
Sorry.
Almost 20 minutes by my watch. I was thinking of something more like 10 o'clock, and then I'd rather favour taking shorter breaks.
Yeah.
Long-
I don't want to.
don't mind having more than one break. You know, I think that the transcriber in particular would welcome more but shorter breaks, probably.
Breaks. Yes. I don't want to throw fuel on the fire, my lord, but I've got 7 minutes on the clock and then 6 minutes on my watch. So there you go. A bit like the mixed use. We've got three alternatives.
Well, yes, I don't profess that my watch is necessarily accurate, but I don't have a magic one of the kind that Mr. Barasi does, obviously. But it's meant to help keep me fit, this one. Anyway.
All of us.
If it helps, my lord, I think we're almost there with Miss Calaresi in any event, but
there we go.
we can take the 2 or 3 minutes if you like, but I think it'll be now more like in the order of 2 or 3 minutes rather than.
Well, let's wait and take a sensible break at a more appropriate moment, and look for appropriate timers to range in your cross-examination.
Fine.
Miss Calaresi, can you hear us? Miss Calaresi, can you hear us?
Yes, I can. Yes.
Thank you very much. Would you just state your full name, please?
Roberta Patricia Calaresi.
Thank you very much. And I'll just ask for the witness to be sworn in.
Yes, please.
Good morning, Ms. Calaresi. Would you please state your full name?
Roberta Patricia Calaresi.
Would you confirm if you'll be taking an oath or affirmation?
I'll take an affirmation.
Thank you. Could you please repeat after me? I solemnly declare and affirm.
I solemnly declare and affirm
That the evidence I shall give.
That the evidence I shall give.
Will be the truth.
Will be the truth.
The whole truth and nothing but the truth.
The whole truth and nothing but the truth.
Thank you.
Ms. Calaresi, I'll just be asking you a few preliminary questions. And when you give your answers, if you could just first wait for the question, talking over each other will cause the feed to cut. And secondly, to be as clear as you can in giving your answer. First of all, can I just ask you to confirm that there should be a solicitor in the room with you, Sophia Kaffour-Camps, is that correct?
Yes, she's in the room, I confirm.
And can I ask you to confirm that you understand that Ms. Kaffour-Camps is there to help you with documents, to find them, but not to give you any assistance with your evidence?
I confirm.
Thank you. Do you have any mobile phones or other electronic devices with you today?
I have my mobile phone.
Could you please turn it off? And then confirm once you've done that. Thank you.
My phone is off.
Thank you very much. So do you have any other devices, perhaps a smartwatch, an iPad, anything like that? Grateful. All right. And then in relation to, do you have any other notes or documents that you've brought with you to help you? Good. Thank you. When you answer questions, even if it's just a yes or a no, would you mind just doing so verbally, please, so that it can be picked up by the transcriber? You're nodding again.
Oh, sorry, yes.
It's unnatural, but if you could help us, thank you. All right, thank you. Ms. Calaresi, could you be passed, please, bundle D? and turn to tab 8.
Yes,
And do you see there a copy of your first witness statement?
yes,
And if you turn to the end of that document of page 173 of the bundle, do you see your signature?
yes, I do.
Now, I will in due course ask you to confirm the contents of that statement, but before I do that, I need to show you one or two other things. Firstly, if we go to the next tab, tab 9, please.
Yes,
Do you see there a copy of your second witness statement?
yes,
And if you turn to the end once more, page 176, do you see your signature there?
yes.
Thank you. Now, can I just, this is just the further thing that I'd like you to deal with for me, if you would, in addition to what is stated in your statement. Could you read, please, paragraphs 10 and 11 of your second witness statement, which you should be on that page?
In full?
If you just read them to yourself, please.
Okay,
Now, since you gave that evidence in your statement, Hexagon has produced some further documents. Have you had a chance to see those documents?
yes, I have.
Just so everyone else knows what we're talking about, could somebody please pass the witness bundle K and turn to tab 2, please?
Okay. Yes.
Yes, you have that. So you'll see there at tab 2 is an email exchange between amongst others, yourself and Mr. Ali.
Yes.
Tab 3, I believe, is an Outlook accepted
Yes.
lunch. Do you see that?
Yes.
And then tab 4 is an expenses report. Tab 5 is an email exchange you may have seen previously.
Yes.
So you've seen those documents. In light of those documents, do you have any further comment that you would like to make about this issue of whether or not a lunch occurred between you and Mr. Ali? Is there anything you'd like to say?
I mean, through the efflux of time, I honestly don't remember or have any recollections that the lunch took place. So, and I see this. I also note that there was a restaurant that was chosen, but then we ended up sitting in another restaurant. I could not find the same confirmation in the email of the change of venue, but I understand that these are the documents and I have no further comments. I honestly cannot recollect the lunch taking place.
Thank you. And subject to those comments that you've just made, can you confirm that the contents of those two witness statements that you have made are true to the best of your knowledge and belief?
I confirm.
Thank you very much. If you'd like to wait there, there'll be some questions for you.
Thank you.
First things first, Ms. Calaresi, can you see and hear me okay?
Yes.
And have I pronounced your name correctly?
Yes.
Thank you. Now, in your evidence, you start out by noting that you took over from Mr. Dean Ferris. Is that right?
Correct.
And although you gave your replacement a handover note, he doesn't seem to have left you with one.
Correct.
But he did leave you with a file?
Yes.
Okay. And can you just describe for us what the form of that file, whether it was soft copy or hard copy, and what it entailed? And if you want some help just in remembering where it is, it's paragraph 7 of your first witness statement, if you want it.
Yes. Yes, it was a physical file.
And was it a file that solely related to this particular project?
I honestly cannot remember.
Okay. And I'm sorry for the rudimentary questions, but this one of the purposes of this process is to try and get to the bottom of all of the facts. So was it a big file or a small file? Was it sort of a huge lever arch file heaving with documents, or was it a little manila folder with a few pages?
I cannot remember.
Okay. Do you remember reviewing the file and familiarizing yourself with the contents?
Absolutely. Yes.
Okay. And what do you remember reading in that file?
I mean, there would have been the joint venture agreement. There would have been some memorandum, some correspondence, which is what you would normally find in a file that relates to a specific matter.
Okay. And what did the memorandums relate to, and the correspondence, if you can recall?
So we have the 2012 memorandum, which I received whilst I was the chief legal officer. And then I also read the 2010 memorandum, which I have recently reread. So obviously I remember it better than had I not read it. And it really spoke about the possibility of revising the amended joint venture agreement. There were discussions or points made on changing the financing to the project that had been already agreed in the AJVA, and the fact that they really wanted to alter what had been the original intention of the parties and reach a different deal. And I think one of the key points that came out of the memorandums, and the 2012 memorandum was a close replica of the 2010 memorandum, was the fact that they wanted to amend the commercial terms and they wanted to finance the project in a different way, which was, I think, the most fundamental departure from the original AJVA, in which the claimant was meant to fund the project totally without borrowing any additional equity. So this was a fundamental point of departure from the intent of the original joint venture agreement.
Okay. Well, should we take it in stages? This you joined in February 2011, correct?
Yes.
And you would have been handed this file from Mr. Ferris shortly thereafter, sometime in February 2011.
I need to correct this. Mr. Ferris had already left the IFC a year prior to my taking on the role. So I did not receive the file from Mr. Ferris. I was just handed over by the office administrator a number of files on matters that were pending in the legal department.
Who was running the legal department in that year after his departure and your arrival, to the best of your recollection?
I think there was a senior legal counsel. They did not have a chief legal officer or general counsel that had replaced Dean Ferris, and it was somebody called Hafid. I can't remember. Yes.
Hafid Farouz? It was him, Mr. Farouz. Okay.
Yes.
So you got this file in around February 2011 from the administrators. Of course, it wouldn't have had the April 2012 memo in it at that point in time, would it?
No.
No. So you think you read the JVA, the amended JVA,
Yes.
the shareholders agreement, and the
Yes.
The 2010 King and Spalding memo,
and any correspondence that, of course, related to that matter. You had some correspondence between a lady called Kira Summers as well, and meetings that were being arranged relating to the 2010 memorandum.
Okay. Was there any correspondence? That correspondence was in 2010. Did you read correspondence prior to that time?
I read any correspondence that would have been in the file. I just cannot recall what correspondence was there at the time. These are the important.
All right. I will show you some, and you can let me in a minute, and you can let me know whether you read those. Now, in your statement, you describe it as the Sheikh Juma issue about Hexagon being a shell company, and and if you want to check, it's paragraph 9 of your witness statement. You say, I wondered whether there was some kind of fraud or wrongdoing in play. Now, just tell me this, that conclusion that there may have been some fraud in play, was that a conclusion you reached in February 2011 when you read the file?
Well, obviously, when I went through the whole file and I saw that the ultimate shareholders had paid 430 million for a company that was just a party to a tri-party agreement, I could not really understand why they would have done that when Hexagon had no proprietary rights either to the land or the joint venture company had not even been set up yet and the project had not been funded. So to the reasonable person, I think there would be a doubt in the person's mind. Okay.
Fraud is obviously a very serious matter, and you had just entered an important job, Chief Legal Officer for the DIFC. What steps did you take to investigate the fraud and satisfy yourself that it was not a fraud?
So we just followed what would have been a normal know your customer process to ask for funding evidence and normal know your customer documentary evidence to support the identification of the parties and the provenance of funds.
Okay, and when you say all of that relating to the acquisition by the beneficial owners, the Al-Majid brothers, Mr. Al-Ramazan, Mr. Papadopoulos.
Yes.
You're talking about their acquisition pre-2006.
Yes, and I would like to point out that know your customer procedures are applied as a matter of standard practice in the IFC for any investments that we do.
Okay. Were you familiar with any of the KYC and other due diligence that had been done by the DIFC in 2007 and 2008?
I was not familiar with those unless it was something contained in the file and documents that we had. But KYC is always refreshed.
Okay. And so you saying that by about February 2011, you had these concerns and you instigated a process for refreshing all the KYC documents.
Correct.
Who did you have undertake that?
I honestly can't remember. It would have been either a member of my staff or myself personally.
Okay, and what would that normally entail? Just walk us through the process.
Just requesting documents. So requesting documents, the bank transfers evidence and passport copies.
And do you recall the actual execution of that process in this case, post February 2011? In particular, whether it was you who sent the emails or whether it was one of your members?
I honestly cannot recall.
Okay. Do you recall receiving the results of this due diligence?
Yes, I recall reviewing all the documents that we had received, and I satisfied myself that it had been a genuine transaction, and therefore the matter was put at rest.
Okay. Well, this you joined in February. February 2011. You reviewed the file, I guess, soon thereafter, and you say you instigated this process. Can you remember when you were able to give this transaction a clean bill of health? In other words, you were satisfied that there was no fraud?
I cannot remember what would have been the date. It would have been a couple of months after that.
Okay. And you specifically remember reviewing passport details of the ultimate beneficial owners and bank transaction details?
I personally don't remember reviewing them right now, given that almost more than 10 years have gone by, but we would have reviewed them at the time to reach that conclusion. Okay,
thank you, that's helpful. So within a relatively short period of time, you had satisfied yourself that there was no fraud involved. Did you take the time to see what the status was of the project?
Yes, of course. I mean, I reviewed the file.
Okay. What did you understand the position to have been in terms of what the parties had done between 2006 and say up to the first King and Spalding memo in 2010? What did you understand that had been the progress of the project?
There hadn't been any progress on the project, with the exception of a shareholders agreement that was signed in 2008 that had not been signed by the original parties to the AJVA, which therefore failed to amend the 2004 agreement, and no joint venture company had been incorporated. No shareholder agreement had been presented by the investor pursuant to Schedule D of the original joint venture agreement, and no proper plan had been submitted on the project. No funding had been put. But beyond that, also the joint venture company had not been incorporated, and without that essential step, the project could really not move ahead. So there had not been much progress in reality.
Ms. Calaresi, I've noticed that in answer to two of my questions, you've given quite a long monologue as to the DIFC's position, that nothing had taken place, there was no shareholders agreement, etc., etc. How have you prepared for your evidence today? Have you had meetings with people? Have you been given documents to read? I
have reviewed my witness statement that I have given myself, and some supporting documents.
What supporting documents were you?
The 2010 memorandum and also an email.
Have you read any of the pleadings or other witness statements?
I have not read any of other people's pleadings, no.
Okay. Have you had any meetings with the legal team on the DIFC side to discuss your evidence?
Absolutely not.
Okay. Thank you. Now, so you say you've given evidence about the things that you say hadn't been done. Were you familiar with any of what I would call the project work in terms of advancing the project, in terms of hiring consultants, coming up with designs, technical meetings and things like that?
Not personally, no.
Okay. So does that mean that your inquiries as to what was going on with the project were limited to the legal side of things rather than the technical side?
Yes, absolutely, yes. And I would have, of course, maybe spoken to people on the property development side as well. I mean, Nabil Ramadan comes to mind as well, who would have been somebody that, you know, would have followed the matter at the time. So there would have been maybe some discussions on the development of the project side as well. I cannot recall due to the efflux of time, you know, but reasonably, I would have inquired about the project development.
Okay. Did you speak to Mr. Mohammed Al-Najjar?
Most likely, he was a team member, so, you know, we would have had discussions on projects as well.
So do you have a specific recollection of having a discussion with him about the status of the project?
I honestly have no recollection per se, but I would have done that as a normal practice when I look at matters.
Okay. Well, I'm going to, if you could be shown F1576.
Okay.
Is this a document that you've seen before?
I honestly can't recall.
You can't recall. Have a read of it. I want to ask you some questions about what's said in there.
Okay.
Did Mr. Farouz, when you joined in February 2011, did he draw your attention to this state of affairs as described? As described here?
I don't recall.
You don't recall. So you're saying you don't recall him meeting with you and discussing the status of the project, or you don't recall a discussion about this particular situation here, not healthy for all parties?
I think I don't recall the specific discussion happening, but we would have definitely had a discussion on the status of the project.
Okay. What do you recall Mr. Farouz telling you about the status of the project when you arrived?
I cannot recall it. I don't remember what he told me.
So as we sit here today, you simply don't know what summary of events and the situation was given to you by Mr. Farouz.
I don't recall. I remember reading the file. I know that Hexagon was a project that had stalled, that had not progressed since the shareholders had entered into, or the joint venture partners had entered into an agreement in 2004. I remember with Hafid having a discussion on the concept holding, shareholders agreement, the 2008 agreement. I don't specifically remember this discussion on this email here, but I would have been very clear at the time that no project company had been incorporated. And the fact that they had really tried, and I think the fundamental point of contention at the time was the fact that the joint venture partner or the investor wanted to change the financing structure of the deal. And that was one of the fundamental points of contention that had not led possibly to the presentation of a valid shareholders agreement, not the 2008 one, because I do not believe that was a valid shareholders agreement. And so matters had not progressed from there.
Okay, so is it your evidence that you have a clear recollection of Mr. Farouz saying to you, the reason this project hasn't advanced is because there's a change in the way that the project's going to be financed? Is that your evidence?
I said this is one of the reasons why the project did not go ahead.
You see, Ms. Calarisi, what we're interested in here is your evidence as to facts, as to what you remember.
Yes.
The proposition that the project didn't go ahead because of financing is maybe here, maybe there, maybe not. What I really want to know is what you recall from Mr. Farouz telling you at the time.
I honestly, after 10 years, I do not recall what he told me.
Okay, he did. And so that means you can't recall whether he said, oh, the block on the project is financing.
I cannot recall.
Okay. Does that mean he didn't say to you, we've got a problem because at the end of 2009, they were pestering us for the incorporation of the joint venture company for an SPA and for the land transfer? You're saying he never told you that?
I didn't say that he did or he didn't. I just said I don't recall what we discussed.
Mm-hmm. Is it fair to conclude that you never read this particular email?
I don't recall whether I read it or not.
Okay. Do you think, as a sort of question of plausibility, if you'd read something like this and you were the chief legal officer of the DIFC, you would have taken some action. Here you have a partner in respect of a very important project complaining about delays and saying it's not healthy and these things have been discussed a long time ago. It seems to me, being a diligent lawyer, if you'd read this, you would have pounced upon it. You would have done something about it.
What we did was we looked at the file again. It's not my job to pounce on anything. My job is to look at the evidence, to understand what the problems are, and to provide a legal route ahead. And fundamentally, the 2008 agreement that had been signed, when I reviewed the document and we formed an opinion internally, was not a valid shareholder agreement, which brings me back to the original point that as per the original joint venture agreement, neither a duly executed shareholders agreement had been signed and neither a project company had been incorporated, being two fundamental obligations on the part of the joint venture so that the project could proceed.
Mm-hmm. Did you understand you're an English lawyer originally?
Yes.
Do obligations as to best endeavors and good faith mean anything to you as an English lawyer? What do you understand them to be? Absolutely, that it's on a best efforts basis that we will try to get the project to be completed and executed and fulfill the obligations under the joint venture agreement. Okay, and what about good faith? That we do things in good faith. But what does that mean? And we all use the word good faith, but what did you understand it to mean, either in legal or practical terms? Good faith is that you do things in good faith. That's what it means. Okay. You don't want to advance anything beyond the words good faith in terms of your understanding of what it means? No, good faith is a very well-known legal concept, and I think all of us here understands what good faith actually means. And you may be ahead of some of us. If you could look at paragraph 12 of your witness statement. This is your first one. Yes. And you say, it's important to note that from when I first joined the DIFCA, it was clear that Hexagon wanted to change the fundamentals of the AJVA. Yes. And you refer to an email exchange in January 2010, yes. Paragraph 13. Yes. And paragraph 14. That's the sole evidence that you rely upon in support of the proposition that Hexagon wanted to change the fundamentals of the AJVA. Yes. Perhaps we can have a look at it. It's at F1706. And I think, Sophie, that means we need to move to volume 4. Yes. Now you've quoted. Did you draft this paragraph of your witness statement? Yes. And what? Why did you quote the sections that you've chosen to quote there? Because of the 2010 and the 2012 memorandums. But but your evidence here is it was from when I first joined. And you're referring to. Yeah, but I mean, obviously, it's a matter of time. It's like literally not on the day that I joined, right? So since very early when I took on the post and I reviewed the files, you know, this is what it looked like. Okay, but here you're talking about when I first joined, this is what it looked like, and you've referred to this email, which is January 2010. Yes. Obviously, at that point, we certainly didn't have the April memo, did we? No, not yet. We didn't have the March memo. Yes. So what was it particularly about this email and the parts that you have highlighted by quoting them in italics that suggested to you that they wanted to change the fundamentals of the joint venture agreement?
It's obviously the fact that they wanted to discuss beyond the documents that had been agreed, as per the email from Ali Jawad, that they wanted to discuss, you know, the structure of the investment in general and the capitalization of the new co.
Well, let's have you've got the email, the full email there, 1706.
Yes.
And if you want to look at the one before, you can go to 1708 and 1707. So,
Yes.
am I right in concluding that these emails were relating on your read to the arrangement of a meeting?
Yes, correct.
Okay. And did you, we've looked at Mr. Farouz's email, not exchange, but the email that he received in December 2009, that it's not healthy for the parties. Yes. Were you aware of that email when you were, and the contents of it when you were looking at this one a month later? Sorry,
which email are you referring to?
I'm talking about the 2009 email that we just looked at.
Yes.
To Mr. Farouz about when he was being chased up about the agreement.
Yes.
The shareholder agreement and so on and so forth. And I withdraw the shareholders agreement reference, the share purchase agreement and the joint venture company issues. Do you want to have another look at it?
No, it's here in front of me. I'm looking at it right now. Yes. Yeah. So I've seen this email. I've reviewed it.
So here he says the investors would like to discuss the structure of the investment in general, the capitalization of the new co, the transfer of the property, and other related matters regarding the joint venture and the development of the project. Why does that suggest, as you say in paragraph 12, that they wanted to change the fundamentals of the AJVA?
So I think it's just a matter of speech. When I said I first joined intending in the first period, when I was there very soon earlier on, I just got that impression.
Okay, but then you go on to quote sections from this email. That's what I'm not following. What in this email, what in that language suggested to you a fundamental change, a fundamental departure by them?
You have to take that together with the April 2012 email that was just later. So all together, this is where I got the impression. And you also had the 2008 shareholders agreement that also purported to change some of the terms of the original AJVA. That was an agreement that had already been signed and that I reviewed at the time.
I must say, Ms. Clarici, I'm not following this. Your evidence is very clear. It is important to note that from when I first joined, so that's when you arrived, so February 2011, it was clear that Hexagon wanted to change the fundamentals. And this is what you rely upon. I don't see how the 2008 shareholders agreement,
yes,
from several years earlier that had been agreed between the parties and discussed and signed, and
yes,
then a memo in April of 2012 that was at least a year away. I don't see how they influenced your thinking, particularly as this is what you've relied upon.
Yes.
So can we agree that the only thing that seems to have triggered your conclusion about Hexagon wanting to change the fundamentals of the AJVA was this document here?
Yes. So I just want to also go back to the 2010 memorandum, and I want to take you to paragraph 17 of my witness statement, in which it clearly says that Hexagon would be responsible for contributing the equity portion of the total cost of the project and procuring financing on behalf of the project company. So this was already included in the 2010 memorandum, which implies that the parties wanted to finance the project in a different way to what had been agreed in the original joint venture agreement, and therefore a fundamental departure from the original intent of the parties.
Okay, I'll come on to that memo in a minute, and we'll spend some time on it. just looking at this as the document that you have relied upon, certainly discussing the structure of the investment in general, that's not a departure from a joint venture agreement that requires the project to be set up, put into an SHA, an SPA, joint venture company, articles of association, business plan for the incorporation of companies. So discussion of the structure and the investment, that's not necessarily departing from an agreement, is it?
But it had already been agreed in the original joint venture agreement. It had already been agreed that the joint venture partner through the investor would be funding the project. So, there was no point in rediscussing it because there could have been no borrowing to develop the project, and it would have had to be an equity injection by the investor.
Okay, so what you're saying is that the JVA was so prescriptive, there was really nothing to discuss about the structure.
Well, this was a fundamental point, that the investor would have put in the funding required to develop the project.
All right, let's look at capitalization of the new co. There's nothing consistent with that about the JVA, is there?
Mr. Strange, I'm loath to interrupt, but the witness, when she arrived, she read the file, so she read everything up to the time when she had arrived, which includes the 2010 memorandum. So I can't quite see why you're focusing on simply the one email. It's all part of the picture that she refers to in paragraphs 12 through to 17, 18, 19, 17, 18.
Yes, you might be right, my lord, but the thing is, the discussion of 15, 16, and 17 is on a different topic. So it seems to me, and I'm going to come to the memorandum, but this piece of evidence is certainly presented as the one as to the fundamental change. So I have to explore this, and I will be exploring the memo as well.
I'm bound to say I don't read the statement that way. You can pursue it if you like. But
yes.
When she first joined, she read the file and she said it was clear to her that Hexagon wants to change the fundamentals. And then she goes through the material in paragraphs 13 through to 18. But
yes, so I'm not avoiding those subsequent paragraphs. I certainly need to go through those.
Well, I'm not finding this very helpful. That's really what it comes to, because it's clear from what the witness has said that she formed that view on reading the file that was available to her at the time, up to the point when she presumably first picked it up.
Fine. Well, I'll move straight to the memo then. Shall we go to that, Ms. Calaresi? That is at F1716. That's the 21st of March 2010.
I apologise to interrupt, but my lord, you may have already marked up a previous copy which you'll find in the J bundle.
I know.
I'm grateful.
Yes.
Can you look for an appropriate moment for a break, Mr. Strange, having interrupted you and spoilt your flow?
That's fine. We can take it now.
Would that be sensible?
Absolutely.
All right. We'll take a 10-minute break now. You know the rules, Ms. Calaresi. You mustn't talk to anybody about the case because you're in the middle of your evidence. Thank you very much.
Thank you, Your Honor.
10-minute break.
Thank you.
When you're ready, Mr. Strange.
Thank you. Ms. Calaresi, I think I heard you say earlier that you'd recently reread this document. Is that right?
Correct.
Okay. And I think what we've established is you don't recall whether you were aware at the time that as at December 2009, Hexagon was pressing, for amongst other things, the joint venture company incorporation and the land transfer.
Correct.
Okay. So if we look at page F1717,
Correct.
You see there that there's a suggestion that the better structure is the JV structure.
Yes.
And did you at the time appreciate that this meant the removal of CHL from the structure and merely relying upon Hexagon?
Correct.
So that would be something that was consistent with the joint venture agreement as amended.
Correct.
Okay. And the second from bottom paragraph, where it discusses, although both the amended JVA and the shareholders agreement both contemplated the formation of the project company, this has not yet happened.
Correct.
What was your understanding in February 2011 as to why that had not happened?
I assume it's because the shareholders agreement, that is one of the fundamental steps for the execution of the original joint venture agreement, had not duly actually taken place. So the shareholders agreement, the 2008 document that purported to amend the original AJVA, had not been signed by the same parties that had executed the joint venture agreement in the first place.
Okay, so from your point of view, it was all down to the absence of a shareholders agreement, nothing else.
Yes, because obviously the parties needed to agree how, what were the responsibilities and obligations of the shareholders and proceed for the incorporation of the joint venture company.
All right. So you then go, you'll see there, we would suggest that the shareholder agreement needs significant revision in order to reflect the correct structure for the project. And to that end, it would be preferable to prepare a new shareholders agreement incorporating elements of the shareholders agreement and the requirements stipulated for any such agreement as set out in the amended JV agreement.
Yes.
Now that would have been, as I understand your evidence and the DIFC's case, you say that the shareholders agreement, the 2008 shareholders agreement, was not a shareholders agreement contemplated by the joint venture agreement. Is that right?
The joint venture agreement did contemplate the preparation of a shareholders agreement. It's just that for it to be valid, it would have needed to be signed by the actual shareholders that were the parties to the joint venture agreement.
So tell me then, in your view, as adopted in February 2011, was the 2008 shareholders agreement an agreement as contemplated by the JV agreement? Yes or no?
No.
Okay. So what was being suggested here in the memo was sensible and consistent with the amended joint venture agreement. Let's prepare a new shareholders agreement. We can incorporate some elements of the shareholders agreement, but it's got to stipulate as set out in the amended JV agreement. So that would be the correct course to take. Would you agree?
No, I wouldn't agree to that. I would agree to a shareholders agreement being prepared in accordance with the AJVA agreement. And if we wanted to amend the AJVA agreement, we would have had to do that with all the parties signing and amending the agreement. So the shareholders agreement would have to be consistent with the original joint venture agreement. And this suggests actually that it is a merging between the 2008 shareholders agreement and the new agreement signed by the due parties.
But what about what to you is objectionable and inconsistent with just using best endeavors and good faith, negotiating a shareholders agreement that takes some elements from the old one and the requirements stipulated for any such agreement as set out in the amended JV agreement? What's wrong with that?
If all the parties had done that and purported to amend the original party, that would have been possible.
But this is the DIFC has essentially asked for this memo to where are we up to? What do we do next? This has been provided. This is a suggestion as to the proposed legal structure. I'm struggling to understand why you say that paragraph is inconsistent with the joint venture agreement, or why you couldn't have when you read that in February 2011, you couldn't have just started negotiations for a new shareholders agreement.
Yes, they could have. Yes, correct.
Yeah. When you say they, you were the chief legal officer of the DIFC. You had an obligation to use best endeavors and good faith to negotiate a shareholders agreement, and here's what's been suggested.
Yes, that's fine, and they could have gone ahead and presented it.
So what you're saying is that you, the DIFC, didn't have to do anything other than sit there and wait for a draft?
No, because it was the responsibility of the investor to do that, to present the shareholders agreement.
So you're saying that the shareholders agreement obligation in clause 3.1 was unilateral and only imposed upon the investor?
Correct. Yes, correct.
And do you take that view, that unilateral view of obligations, with respect to all of the obligations in clause 3?
What is clause 3 you're referring to?
Clause 3.1 of the joint venture agreement, incorporation of the JV company.
Can you give me the clause 3, please?
Could you show her the document, please, in fairness to the witness?
Three point 1.1.
Yes, and Sophie, I don't know if it's possible, but if you could probably show her the amendment agreement at the same time as the JVA, so she can see the differences. So you've said that the shareholders agreement obligation is unilateral. What do you say about the balance? Do you say they're unilateral or mutual?
The balance.
Yeah, so the other obligations in that clause.
So it says the party shall execute and next shall procure that the investor executes a deed of adherence in a form approved between them pursuant to which the investor shall agree to be bound by the agreement as a party. Thereto, and to perform a, yes.
You don't need to read them out. Ms.
No, I'm trying to
Gallarese.
read them out because it really talks just about the investor executing a deed of adherence. So I can't see what are the other obligations you're referring to in the clause.
Okay, have a look at 3.1.3.
Yes. Yes, in a form prepared by Nexus, in accordance with the provisions of Schedule D. Yes.
And look at 3.1.1.
Yes.
So this is an amended agreement. I don't know if you have that. Do you have that in front of you as well?
Yeah, can you refer to the clause in the amendment agreement that you're referring to?
Yes, 3.1.1 should start, the parties shall proceed immediately to incorporate a limited liability company.
No, I don't have that. In the amendment agreement, it says counterparts 3.1. So maybe this is amendment to the joint venture agreement. Let's see.
Sophie, I'm happy for you to show her the clause if it speeds things up.
Three 3.1.1 is counterparts. It says clause 3.1.1 shall be deleted. I don't think that's what it
Yes.
says.
Yeah,
Okay.
and then underneath there should be some text.
Okay, yeah, or reference to the box. Okay.
So you've now seen the obligation relating to the share purchase agreement and the incorporation of the company. Is it your evidence that, like the shareholders agreement obligation, that is unilateral? In other words, it rests on the Hexagon side, not the DIFC side.
Well, as per the amendment now, reading on the amendment, it actually implies that it applies to all parties.
Okay. What about the shareholders agreement? Do you want to change your evidence on that and say that it's mutual and not unilateral?
No, I don't want to change my evidence.
Okay, so you say it was the shareholders agreement was a unilateral obligation only on the Hexagon side. Okay, so does that mean, if you look, and this is in the amendment of the JVA, clause 3.2, where it says the parties shall use their best endeavours in good faith to complete the steps and procedures set out in clause 3.1 as soon as reasonably practicable after the date of this agreement. Are you saying that best endeavours and good faith obligation there didn't apply to the DIC as regards?
No, of course they would apply. Of course they would apply, yes. Yes.
So it applied to the shareholder agreement requirement, but only to Hexagon.
Well, obviously, we relied on Hexagon to prepare the shareholders agreement. I mean, that's the fact.
Okay, all right. So can I summarize this? From the moment you familiarized yourself with those two agreements and the file, you were of the view that the obligation as regards the shareholders agreement was on Hexagon and they had to present you with one.
I think this may have been the understanding at the time.
Okay, all right. And well, could you can put the joint venture agreement and the amendment to one side for a moment. And go. And you've still got the memo there?
Yes, I have the memo.
Do you agree that to reading those words there, that is a proposal that the parties prepare a new shareholders agreement?
Yes.
With Hexagon as the party?
Yes.
Okay. And based on the evidence you've just given, is it right that as at February 2011, you rejected that proposal and considered it something for Hexagon to do by itself?
I didn't reject any proposal. If Hexagon wanted to present a shareholders agreement, they could have done so. The point of the fact is that they never presented a revised shareholders agreement.
Okay. Now here, in the next paragraph, there's a reference to the starting point for the new shareholders agreement would be that the DIFC contributes the land on which the project will be developed to the project company. Consistent with the joint venture agreement in your view?
Correct.
And then it says, and that Hexagon contributes the agreed working capital of the project company. Consistent Correct. With the joint venture agreement? All right. And then it says, Hexagon will also be responsible for contributing the equity proportion of the total cost of the project and procuring financing on behalf of the project company.
Yes.
What do you say about that in terms of consistency with the joint venture agreement?
So the statement is not fully consistent. Well, it is consistent until we get to the brackets, but procuring financing on behalf of the project company is not a matter for us to discuss. For us, we only need to know that Hexagon will be responsible for contributing the equity portion, and the equity would have had to be injected into the joint venture company.
Okay. Do you agree that if the joint venture company wasn't the borrower,
The joint venture company is not the borrower.
No, this is a question, so just let me finish it. So listen carefully to my question. I want you to assume that the joint venture company is not borrowing anything in its own right, so it doesn't enter into any loan agreements. But Hexagon, or through its affiliates, secures financing on behalf of the project company for the project. Would you say that was consistent or certainly acceptable under the joint venture agreement?
Provided that this is not anything that is reflected in the books of the project company, Hexagon could have raised finance as they wished.
Okay, thank you. Now you'll see here in in big C corporate details, and I can't find in the documents that we have for this case any evidence that KYC documents were provided by Hexagon, and in particular the entities you see there, Ruby Gate and CHL, to you after February 2011. So I want to check, was this what you were thinking of when you say you checked the KYC and were satisfied?
I honestly don't recall. It was a very long time.
Okay. In terms of preparing your witness statement and providing information to the DIFC for the preparation of this case, were you given access to your email account or your files or other documents that you used when you were at the DIFC?
Absolutely not.
Mm-hmm. You didn't ask for those documents to refresh your memory and check where things were up to and what happened when?
I had access to some documents, which are the shareholders agreement and some of the correspondence I've said at the beginning of this conversation.
So does that mean the answer to my question is no? You didn't say it would be helpful to have my emails and it would be helpful to have the files I maintained in respect to this project for the preparation of my witness. Don't you think you're an English solicitor, correct?
I'm an English lawyer, yes.
Well, what's the difference between an English lawyer and an English solicitor?
I have a law degree and a master.
Are you qualified? Have you been admitted as a solicitor?
Not in the UK, no.
Okay. All right. With the word qualified, what does that mean to you? Does that mean you've done a degree, or does it mean you've passed the LPC or the bar and you're admitted?
Qualified in the UAE.
I see. Okay, but not in England.
Okay. Yes.
Don't you think it's an unsatisfactory way for a lawyer to prepare to give evidence about a period of time when they were a chief legal officer of an important institution and not have their emails and their files and other contemporaneous documents?
I would have access to the documents that I refer to in my witness statement as copies of documents, but why would I have access to my emails? They belong to the company.
Well, if it was me and I was giving evidence on behalf of the company about a 3 or 4 year period, and I was being asked to put a statement of truth to a document describing events over a period of time, I would certainly want all of the contemporaneous documents. I'm just puzzled as to why you didn't ask for those.
I have reviewed all the
documents.
I have reviewed all the documents that I refer to in my witness statement.
Were those documents given to you by the DIFC, by the legal team there?
That's correct.
So they chose what documents you would read and refer to in your witness statement. I just want to get the sequence of events. Were you given documents, then you drafted, and then gave them the statement, or did they give you the documents, then you drafted?
No, I discussed what I recollected, and I asked for the documents of the things I recollected and discussed, and the fundamental documents, and I was given those. And then obviously I drafted my witness statement.
Okay, thank you. Now, if we can go to D, please, next steps. We can leave aside, now that we've clarified the position on on your evidence as to the mutual and unilateral obligations and the amended joint venture agreement. Either way, do you agree that the steps that are suggested there were the appropriate steps to be taken under the amended joint venture agreement to move it forward?
Yes, with the exception of the fact that they mentioned that Hexagon will be contributing equity by, either equity or shareholders loan or a combination of both. But yes, those would have been the correct steps to progress on the project.
This is, and then just to be clear, I'm looking at D, next steps.
Yes.
Yeah. Okay. And were you, when you read this memo, did you ask Mr. Harouz or anybody else as to what response the DIFC had sent or what the position was?
I don't recall, because I think not much was done between 2010 and 2012 when we received the replica of this memo.
Okay. Now, you, in terms of the things we see set out in next steps, did as far as you're aware, did you or did the DIFC rely upon what was said there in any way?
The DIFC relied on the statement.
Yes.
Indeed.
Did you read that and say, well, because of that, we're going to do X, Y, and Z? What was the reaction as far as you're aware?
I honestly don't recall what was the reaction.
All right. Could you please be shown the first witness statement of Gaith Hosson, please? It's a D4. And if you could go to paragraph 20, please.
Okay.
Now, Mr. Hosson here refers to some meetings that took place in January 2010.
This is not the part. This is not the one.
It's page 9, paragraph 20.
No, this is not the document.
That may be my fault in the sense that I've given you a bad reference. Let me get it up electronically. So it's definitely the witness statements bundle.
It may be D3, page 54, paragraph 20. Is it Mr. El Fadl's statement?
No. No.
That refers to a meeting on the 28th of January, but
no, it's in the earlier bundles. So if you could take out it's the H bundle. And I believe it's 22. Is that right, Leslie? Oh, it's 18. Sorry. H18. Yeah, that's tab 18 of the H bundle. And it's 17 May 2019, the date of the document.
What paragraph?
Have you've got the document?
Yes.
Yes, so paragraph 20. Is this a document you've seen before?
No.
Read?
No.
Okay. Okay. Well, he refers to. Would you like an opportunity to read those paragraphs?
Yes.
Why don't you read 20 to 25 then? I'll have some questions for you.
Okay.
What was Mr. Hosson present at these meetings he's referring to here?
No, I don't think so because he wasn't present at that point.
No, that's what I thought. No,
Yeah.
Okay.
Now, Mr. Hosson refers in paragraph 24 to a presentation which included financial models based on costs and market assumptions. That document, if you can be shown the F bundle, please. F80. That's volume 1, page F80.
Okay.
Now this is the presentation. You can see from the front page, brief business plan concepts for discussions between consortium members. Do you recall seeing or reading that document as part of the diligence you did when you arrived?
I don't recall.
Okay. Do you remember Mr. Farouz telling you about that meeting or the presentation of that document?
I don't recall.
All right. What did you understand to have taken place between the parties for the balance of 2010 and 2011? When I say that, up until your arrival.
I honestly don't recall.
Okay. If you could now please be shown the first witness statement of Mr. El Fadl in the D bundle. And it's D3. Yeah, tab 3, paragraph 28.
Okay.
These with these events, as he describes there, his meeting and communications. Sorry, I withdraw that. He says, I also communicated with Mr. Mashawa. Did you have any discussions with Mr. Mushawa regarding the interactions with Hexagon during this time, during 2010?
I don't recall.
Okay. What about here you'll see he refers to a meeting that Mr. Al-Majed had with Mr. Al-Shihli, during which this is in paragraph 29.
Which paragraph is this that you're reading on?
This is the next one down, paragraph 29.
Sophia, this is not, so am I in the first witness statement, paragraph 21?
Yes, of Abdul Sami Al-Fadl.
Okay. Okay, yes. Okay, yes.
So you're aware that he was managing director of the DIFC at the time?
He was managing director of DFC Investments.
Yes.
A subsidiary company, yes, of DFC.
Yes. Yes. And was he in position when you arrived in February 2011?
Yes.
Okay. Did you have any discussions with him about his interactions with Mr. Al-Majed?
I don't recall.
Okay. Did he or anyone else tell you upon your arrival that the DIFC wanted to put the project on hold?
I do not recall.
You don't recall. So it could have been said to you, you just don't remember, or you don't recall that ever being said?
I honestly don't recall that ever being said, for the very reason that at all times it was in the interest of the DIFC to proceed with the projects. Land in the DFC is prime real estate land, and I couldn't think of why we would not want to proceed.
Okay. Is it right that during this time, 2010, 2011, two things were happening? One, the after effects of the global financial crisis. And second of all, there was a great deal of turnover in management level positions at the DIFC.
Somehow, yes.
When you say somehow, does that mean, yes, those things were present and were having an impact?
I mean, there were some people that left, but not everybody left.
Mm-hmm. What about the impact of the crisis on the DIFC's appetite to pursue property development projects?
I think the appetite was always there, and given that the DFC was contributing land, this was the model that we had with joint venture partners, and so that we had the land already. It would have been at no additional cost to us. So even though there was a crisis, this specific project could have progressed as it was envisaged.
Okay. Now, if you could move on to 1720, please.
S1720.
Yes.
Yes. Okay.
Could you tell us, please, who or the position of Shahil Akram at the DIFC?
He was the managing director of DIFC.
Okay. Now you'll see there that there's an email from Mr. Ali to him. We look forward to hearing from you once you've had a chance to review. Did you discuss, well first of all, did you recall seeing this email in your file?
I don't recall.
Okay. Did you make inquiries or have any knowledge as to why the DIFC hadn't at that point responded to the memo and the suggested way forward?
I don't ever recall discussing this memo particularly. It's dated 1 year, almost 1 year before my joining the DIFC, so I don't recall.
Okay, all right. Who within the DIFC did you discuss this 2010 memo with? Who was your source of knowledge as to where things were at?
So I would have discussed with Shahli Akram and with Hafid at the time, and Nabil Ramadan. So yes.
And can you recall what they said to you about the project and it moving forward and this memo?
They would have always wanted to be the intention to progress on the project. However, we still had not agreed on the shareholders agreement.
Okay, so and for how long was that your view, one you've just described, intention to progress the project but hadn't agreed on the shareholders agreement? At what point in time did you abandon that view? The intention is to progress the project.
I think we never abandoned that view. I think that view was never abandoned. We just decided in June 2012 through the renunciation letter to terminate the agreement due to the efflux of time, the fact that fundamentally there had been no progress over 10 years, no, like slightly less than 10 years had gone past. And the parties wanted to change the fundamental terms of what had been originally agreed.
All right.
But we always, sorry, just to continue, we always actually went back to them and said to them if they wanted to progress with the project, to present a proposal, and that we would give them a first right of refusal, and we would want to continue to develop the project. So our door was always open and our intention to develop was always there. Okay.
So you've said there was an intention to proceed, but then you sent the letter in June 2012 because of the passing of time. At what point between your joinder in 2011, February 2011, and your familiarization, and that June 2012 decision to send the letter of 12 June, did you, in your own mind, advise the DIFC to change their approach and bring the agreement to an end?
So the lawyer on file who gave the advice was a member of my team, which of course I reviewed. The matter was discussed internally, and it was agreed that the project was not progressing, and there had been so many discussions over the year, and therefore we felt that due to the efflux of time and the fact that the parties had not complied with their major obligations under the shareholders agreement, that the agreement had come to a termination.
When you say the parties have not complied with their major obligations, what major obligations had the DIFC not complied with?
Well, I can't think of anything, but the substance of it would have been the fact that, the shareholders agreement had not been agreed and the joint venture company had not been incorporated and funded.
Okay. And you said, you talked about discussions. Are you saying there were discussions with Hexagon about this state of affairs that you considered to exist? In other words, are you saying that the DIFC said to Hexagon, we don't think this is going anywhere. We don't think anybody wants to do it. We're bringing things to an end.
I mean, my discussions were internal discussions, so I don't know if there were any discussions with Hexagon, but ours was a legal position that was reached internally based on the state of affairs.
Do you agree that it would, if you had a agreement with a partner to pursue a project, and the last document you'd received from them was a desire to move forward, largely consistent with the joint venture agreement, you at least owed it to them to let them know that you were bringing it to an end because you felt the passage of time had meant that nobody was going to proceed?
Yes, but we did tell them to please come up with a proposal to send in the shareholders agreement. But I think the fundamental point of the whole matter was the fact that the ultimate shareholders had paid a very large amount of money to a company that had no rights to a piece of land that needed to be developed. So they had to fund the project. It doesn't really matter whether we sent a renunciation letter, because we always said to them, come back with a proposal, send us a proper feasibility study, a design, and we will consider it in good faith going forward, and you will be the first investor that we will include. So the substance of the intention of the original JV was still there. It's just that we were at a standstill on the point of having a shareholders agreement that reflected the original joint venture agreement.
Your evidence was a moment ago, yes, we did tell them to please come up with a shareholders agreement. When, after February 2011, did the DIFC tell Hexagon to please come up with a shareholders agreement?
Well, they came back to us and they told us in the memo, in the April 2012 memo, that they would be producing the shareholders agreement. So it's actually them who said that they would be producing it. That shareholders agreement was never produced.
But that's rather academic to the discussion we're having now, because you're saying that your colleague presented in November 2011 a memo saying that the transaction was dead and terminated. And your evidence just a moment ago to me was where we did tell them to come up with a shareholders agreement. So between February 2011 and November of 2011, when did you tell Hexagon to please come up with a shareholders agreement?
We've been telling them all along. So this has been a discussion that happened all along. So it's not something that was secret or never discussed. It was all the time the intention that the shareholders agreement had to be signed as per the joint venture agreement.
So when you say this had been a discussion that has been happening all along, does that include between February 2011 and November 2011?
I would assume so. I mean, the position wouldn't have changed.
Okay. And then you say we've been telling them all along. Who is we on behalf of the DIFC in terms of individuals? And
it would be the management of DIFC.
Let me finish the question. And who is they in terms of individuals at the DIFC?
It would have been the management of DIFC and whoever would have met with Hexagon.
Okay. Are you basing this on direct knowledge, or are you speculating?
I am just speculating that that's what they would have done. Mm-hmm. I did not attend meetings between Hexagon and DIFC. These meetings were not attended by me in person.
Tell me, when you were at the DIFC, was it your observation that important decisions about agreements like this were the subject of internal meetings and minutes were kept and memos were exchanged and documents passed, or was it very laissez-faire in terms of approach?
It's not laissez-faire. Matters that required my attention and my direction would have come to my attention, but DIFC was an independent company with its own management and its own advisors.
Well, I still repeat my question. Were documents generated in discussing decisions like this agreement on what should happen and whether the Hexagon should be asked to come up with a shareholders agreement?
Yes, that is an obvious point, that Hexagon was going to come up with the shareholders agreement. It's in the joint venture agreement. It doesn't require any decision from my part.
I'm more focused on documents. My difficulty is, and this is why I'm pressing you on this topic, is other than the memo going to the DIFC suggesting the way forward, and then the minutes of meeting, if you want to have a look at them, they're at F1751.
Yes.
And if you go to the page, that's the minutes, and you can see you attended as secretary of that meeting.
This is the board meeting of the DIFC authority.
Yes, correct. Yes. And you'll see you at that meeting in two capacities, as a presenter and as secretary. And if you go to page 1754,
Yes.
We have no documents at all internally to DIFC as to the position that led to this view that's expressed there. And my question to you is that report that Sahel is giving, is that of his own volition without discussion, or has that decision been reached following internal memos and views and meetings?
It would have been reached following an internal opinion that Suhail would have prepared, which he would have discussed with myself, and I would have been in agreement with, and also senior management.
Okay. And is it fair to say that the team, the project team, the investment team that had historically been dealing with Hexagon would have also been asked to express views?
I cannot comment on that. I don't know.
Well, is it usual for the DIFC to bring a contract to an end without talking to the commercial team that's dealing with the counterparty?
There would have been discussions. I was not just party to those discussions. I would have been consulted on the legal view of the matter.
Okay. But you say, as a matter of fact, there would have been consultation with the commercial team dealing with Hexagon. I would
have assumed so.
Okay. So have you asked for these documents relating to this decision, the memo from Sahel and the input of others from the DIFC to help you?
I wouldn't know if there were any documents. I was not part of those discussions. I would have reviewed the legal opinion and discussed the legal matter.
Okay. Does the absence of any contemporaneous communications from the DIFC between February 2011 and November 2011, when this position was taken, does that absence suggest to you that you may be wrong and the DIFC never wrote or communicated to Hexagon, please come up with a shareholders agreement?
I mean, everything is on file and has been shared. So those are the communications that would have taken place.
Okay. And here he says and explained that the joint venture agreement is now terminated. And what did you and he mean by is now terminated?
That the agreement was terminated. It was no longer effective.
Mm-hmm. But as a legal matter, what did you mean? We've sent a termination letter and we've said this agreement's over, or it's terminated simply on its terms?
It's terminated on its terms.
Mm-hmm. And what term of the joint venture agreement did you have in mind?
Well, the entire agreement is terminated. All of its terms are terminated.
What was the mechanism for that, though, if you hadn't given notice?
It was the renunciation letter.
But this says, is now terminated. This is November 2011. That letter didn't come until June 2012.
Yeah, correct. That's when we informed them, yes. And there would have been discussions internally on the legal position. So we formed that view in November, but it was communicated officially on the 12th of June 2012.
Okay, so 7 months later.
Correct.
Now, between this and June 2012, neither you nor anyone else in the DIFC alerted Hexagon to this decision.
I do not. You have all the documents.
But I want your explanation. You're the chief financial officer.
Yes.
You're at a meeting where you say an important agreement is terminated. You've seen the memo where they're saying let's get on with it. Leaving aside common courtesy, ought you not tell them that's your view immediately?
We did inform them in June that that was our view. They had, from the time they submitted the memo in April 2012, to come up with a shareholders agreement. They didn't. And
if that was your true position, why didn't you send them a letter saying, you've got until X time, we're ready, willing and able, we want to get on with this. Why don't you send us a shareholders agreement so we can move things forward as per your memo?
I believe that view was shared consistently in all meetings that took place with Hexagon.
Okay. And when you say all meetings, you mean all meetings throughout 2011?
Yeah, or even before that.
Okay. All right. And you say that message was clearly put in writing both before
I didn't see that message was clearly put in writing. I said that message was an obligation under the joint venture agreement and was one of the fundamental steps that needed to take place so that the joint venture company could be incorporated and the project could continue. Okay. All right. Well, tell me this. You've referred to the parties being in breach of their major obligations under the JVA. Am I correct in saying that from this point forward, the DIFC had no intention of exercising best endeavors, let alone best endeavors, to pursue any of the clause 3.1 obligations? We always had best endeavors intentions to progress the project, but under the terms of the original joint venture agreement, and that didn't take place. So, today we are in 2022 and we're still discussing the same matter. That's literally, almost 16 years later. Okay. I could say that's how the legal system works and we are where we are, but I'd rather focus on my question. Is it right that as the chief legal officer of the DIFC had no intention from that moment forward, the date of this meeting at least, of using best endeavors or good faith to pursue the clause 3.1 obligations that it had? It's a simple yes or no question. We always intended to pursue the obligations to develop the project until we felt that the project was not going anywhere. Mm-hmm. Do you understand the distinction between best endeavors with respect to a project, which is the actual development of the land, and best endeavors with respect to contractual obligations? Do you understand that distinction? Yes. Okay. Well, I want you to ignore best endeavors with the project and just focus on best endeavors with respect to the contractual obligations. The IFC complied with their obligations under the project, under the contract. Okay. So sorry to check on this. I'm a little over fastidious with these things. So you say you're UAE qualified, so that means you're a lawyer registered in the UAE. Okay, fine. My lord, that's probably an opportune time.
Yes. Best estimates, timing-wise?
I think I'll get to Mr. Visser today.
Right. Okay. Well, we'll take.
Yeah, and I probably will get to him, with more than night watchman time.
Yes, I was merely inquiring so that arrangements could be made to make sure he was here when he might be required. That's all. Is there any difficulty about that, Mr. Montague-Smith?
No, my lord. Mr. Viss is available whenever he's needed.
Right. Okay.
I mean, it would be helpful to know whether he's likely to be needed tomorrow as well, but only for this.
I won't finish him today.
I see.
And again, I'm always flexible as to whether we start him today and finish him tomorrow, or just start him tomorrow. That doesn't bother me either way.
Right. And just looking a little further ahead, what does that mean for the experts?
I mean, I've always envisaged the experts on Thursday and Friday, and not tomorrow. And I think we discussed, although it was an agreement to agree, not binding, obviously, that whatever time, if we finished early tomorrow, that would give your lordship some time with the expert reports for the rest of the day.
Yeah, well, I spent a happy weekend looking at those.
My condolences.
No, well, I'm sure I could benefit from more time spent with them.
I mean, if it helps, my lord, in terms of time estimates for the experts, we'd estimated a day, and I think my learned friend estimated half a day. Sorry?
That's what I thought, which suggested we might be through them on Thursday, but I appreciate estimates change.
I think if anything, mine would come down slightly. At the moment, I would estimate around 3 to 4 hours, but I would be very, I think it would be a surprise if it was more than a day. So if we were to start on Thursday, we will finish on Friday, I would have thought, as long as my learned friend isn't underestimating.
All right, very good. Well, we'll take a 3/4 of an hour break now, and same rules apply as before, Ms. Calarese. Thank you very much.
I'm ready whenever court and the witness is ready.
Yes, please carry on.
I am ready.
We were discussing this minute of meeting from 17 November 2011. The position taken at that meeting, it's not clear whether it was endorsed and accepted and pursued or whether the view was just expressed. Can you enlighten us?
I mean, at the time, I do not recall what happened, but obviously the fact that we issued the renunciation letter in 2012 June, I would assume that by that time it was endorsed.
Okay. Is it your evidence that the key commercial people within the DIFC dealing with Hexagon with respect to the project were informed of the outcome and the decision that had been made at this meeting?
Yes, I would assume so.
Okay. And would that have been in a matter of hours or days? Let us into how quickly you would have informed them of the position.
I mean, I honestly don't know. It would have been a matter of days.
Okay. All right. And did you tell them that they should make clear to Hexagon that the deal was off and avoid having further discussions with them about commercial matters?
I would have assumed yes. The person would have been Sohail Mohedin, who was the lawyer of DIFC at the time.
Okay. Because do you agree with this? It would have been misleading, amongst other things, and unfair to have taken a view that the contract was over and done with, but continue to engage in discussions with them regarding the project itself.
I don't think it would have been unfair, but
why not?
Because we always intended to progress with the project, and so the door was kept open.
So they've hired around 10 consultants. They've sunk 4 or 5 years into it and a lot of money, and they've been pressing to get on with it. And you've decided it's not happening with them. It'll happen elsewhere.
No, we didn't say it will happen elsewhere.
Let me finish the question. And you've decided to jettison them, but you're just not going to tell them that for a period of months while they come and make presentations to you and so on. And you think that's fair and reasonable?
I didn't say that we would not have continued the discussions with them had they come up and presented in the time the shareholders agreement. As I said, at all times we kept the door open and we always gave them a first right of refusal. And we went back and told them that, you know, they could come back with a proposal. So we never closed the door on them, and we never intended not to consider anything that they presented to us. As of them engaging consultants and spending so much money, I know that they had said that they would send us something, but we didn't receive any revised project documents from them, or consultants or feasibility studies.
Could you have a look at page 1760, please?
Yes.
This is a presentation that was delivered in February of 2015.
Yes.
Was this a document you saw at the time?
2012, I think.
What did I say? Oh, sorry, my apologies. Yes, you're right. 2012. Did I say 15? Yeah. So line 17, page 96, transcriber, if that could be struck in 2012.
Yes.
My mistake.
I mean, I don't recall seeing it at the time. I may have seen it, but I know that they never presented out of this a revised project design. Nothing came out of it. So it was a presentation that said they would have possibly done that, but nothing came out.
And that present at that meeting was Mr. Merlin Curran, who was the executive assistant to the deputy CEO. Do you remember having discussions with Merlin about this document in this meeting?
Absolutely not. Merlin was the secretary of Abdallah Al-Awwal.
Okay. Did you have any discussions?
No.
With Merlin? Okay. What about with Mr. Nabil Mohammed?
No.
So you never knew what was said and represented at this meeting?
No.
Don't you think that's problematic given the view that you had reached in November 2011, that they're presenting as to the status of the project and they're going through revised concept designs and suggesting a way forward, and they're oblivious to what you've already decided? Look at page 1778, for example.
Yes. Correct. So what would you like me to say?
So is it your evidence that you had not had any discussions by the time of this presentation in the meeting with Mr. Nabil Mohammed about the decision to terminate?
I may have, as I said, I do not recall. It was 10 years ago.
Okay. Well, the fact that he attended the meeting, received this presentation, and appears to have engaged with respect to the project and moving things forward would suggest that he hadn't heard from you. Is that a fair conclusion?
Would suggest that
he had not heard from you, that as far as the chief legal officer was concerned, the contract was over.
he may have been informed by Suhail Mohideen. I honestly do not know. I did not deal with this matter in DIFC Investments. There was an assigned lawyer and they had their own management. So it's possible, I cannot comment. I honestly don't know. But the bottom line is nothing was ever presented out of this.
Okay. If you could go to 1786, please.
Yes.
You'll see here it's Mr. Abdul Sami reporting to his principals. He's referring to a call he's received from Nabil
Ramadan, yes.
Yeah, his request is to send an official letter explaining the history and background of the relationship with the DIFC and the project, and copies of the agreement. You accept that that is the catalyst and the reason why the 26 April 2012 memo was sent?
Okay.
No, that's a question. Do you accept that?
That this is a catalyst for the April 2012 memo?
In other words, there was a request for information that we see there, and the response to it was the memo, which we then see at 1787.
Yes, so this is the 2012 memo. Yes.
Okay. And you'll see there on page 1788.
Yes.
There's a reference to the fact that no substantive response has been received from the DIFC regarding that proposal.
Okay.
Why, since you are now in situ within your role, you
Yes.
had educated yourself as to this transaction. You had read the March 2010 memo, and you saw the contents of that. And you hadn't responded at all to it yourself. No
Okay.
response to it. And you're the chief legal officer who has formed the view that the project is terminated because of the effluxion of time. Why, when you got this memo and read it, wouldn't you have gone back and said, oops, we thought you didn't want to proceed, or here's our counter proposal, or give us a shareholders agreement, or what do you propose? Why didn't you react that way to this?
I mean, honestly, I do not recall, but as I said again, I was the chief legal officer of DIFC Authority. This matter was a real estate matter handled by DIFC Investment with teams and people dedicated to this matter. So I looked at the legal opinion, and which was endorsed by me. But as to what happened when they received this, I do not recall.
Do you recall getting this memo in around April 2012?
I do recall getting this memo, yes, in 2012.
Mm-hmm. Why didn't you then comply with the DIFC's obligations to engage in good faith and use best endeavours to start negotiations with the proposal put in 2010 and again here in terms of
Yes.
next step and pursuing
Yes,
the legal structure? Let me finish the question. And the proposed legal structure under the JVA. Why didn't you?
Yes, because there were discussions that continued to take place, and the renunciation letter did not go out until June, which means that we were considering the steps of the JV partner and what they were doing. But as I said, I was not part of the discussions between the JV partner and the DIFC Investments.
There seems to have been an unfortunate communication gap between you and those dealing with the commercial discussions. Is that a fair conclusion to reach from your evidence?
The lawyer that would have been on the team dedicated to the DIFC Investments would have had part of all of these discussions.
Okay.
With the commercial.
Is it your evidence, though, that when you read this memo and lines like, we have not received a substantive response, and the position in relation to next steps and a shareholders agreement, you reconsidered your position as to whether you would go ahead, and there were more discussions internally that then resulted in June renunciation letter? Is that how I should understand your evidence?
Yes. And I think that nothing came out of the 2012 April memorandum, which was really a rehash of the 2010 memorandum. So 2 years had gone by, and neither a shareholders agreement had been presented, nor any kind of feasibility study or proposal for the development of the project. So if there was an urgency or matter, they would have already done this.
I see. Do you accept as a matter of practicalities and commercial reality between parties that you can only agree things like a concept design, like the parameters for a feasibility study, like the contents of a shareholders agreement, if you both work together and cooperate? Do you accept that as a fair commercial premise?
I accept that as a fair commercial premise.
Do you also accept, on the basis of all of the contemporaneous documents that we've been through and your evidence today, that the DIFC certainly wasn't keeping up with its side of the bargain in terms of cooperating and engaging with Hexagon during this period?
I may not comment or deny that, as I do not have all the facts and all the discussions that took place. I can only comment on what I was part of.
Is there anyone else from the DIFC or the DIFCA who could comment on that if it's not you?
The people involved that are on the emails that are part of the discussions.
Okay, all right. If you could please take up for me page 1794. This was presented in early May.
Yes.
Was this the document that you saw at the time?
It's the same one that we discussed before. I do not recall seeing it, but I would assume I would have seen it because this is a working document that would have been presented to the team of DIFKI.
Okay. If you look at the first slide, it says background. So this is on page 1795.
Yes.
Last bullet. However, the matter was put into a freeze mode following an internal restructuring of the DIFC. Did you investigate what that freeze mode was and take it into consideration in terms of your decision as to what to do with this agreement?
I would have assumed at the time, but it was a freeze mode, so I was not there at the time. I cannot comment as to what happened between 2009 and 2010.
Okay. But my question has another limb to it. Did you factor that into your considerations as to what to do with this particular project, given that they were saying to you, the DIFC, have put it in freeze mode?
I honestly do not recall, and I know that we would have progressed on the project had they submitted the relevant documents.
Okay. If you can, could you please look at 1807. Were you aware there of any of the background issues in terms of the mix and the affection plan and the GFA?
No, I don't recall.
You don't recall being aware of that, or you just simply you weren't aware of it?
I don't recall being aware of it.
Okay. What about the event that, if you could have a look at 1810, please. Were you aware of those events? And in particular, if you look at the last bullet, after which there were little or no communications with the DIFC.
Yeah, no, I am not aware of this.
Did you remember reading it at the time?
I don't recall.
All right. If you have a look at 1814, please, it's a note from Mr. Sami to Nabil Ramadan.
Yes.
Was that was that email and the contents ever provided to you for discussion?
I don't think so, but I don't recall.
All right, we'll have a look at 1835. There, Nabil is responding on the 8th of May, and he says, I've received the original documents. Currently, our team is reviewing this, and we shall revert back to you within the next 2 to 3 weeks.
Yes.
To the best of your knowledge, between that period of the memo, the presentation, and the email, which it was supplied on the 2nd of May, did the DIFC take any steps internally with respect to advancing the project? For example, was the decision made, no, at this point we must start discussing a shareholders agreement, look at a JV company, incorporation, etc.?
Like I said, I was not the actual lawyer on the ground. I assumed that they would have had discussions between the legal advisor and the team in DIFKI, but I cannot comment for them. So I really don't know what happened in between.
Can you explain to us, please, what is the differentiation between the legal function that you were head of and
Yes.
the legal function at DIFKI? Who had final say?
So decisions that were fundamental, such as, for example, the termination of the joint venture agreement, would have come back to me, but DIFKI was an operational company subsidiary that had its own management and its own team of people that dealt with the day-to-day transactional matters pertaining to DIFKI's business.
Surely this then was something that came within your jurisdiction because it was fundamental.
But here they're still discussing, you know, an issue that has been ongoing for a very long time.
All right. Well, the next inter partes communication we have is at 1839. So if you can bring that up, that's Sahil Akram's letter of 12 June 2012. What discussions do you say took place between Mr. Ramadan and your team between the 8th of May 2012 and the 12th of June 2012?
What happened on the 8th of May? Why do you use the 8th of May as a date?
Well, that's the date that Nabil is saying to Abdul Sami, currently our team is reviewing. So there was obviously some review and some discussion between the 8th of May and the 12th of June. And I would like your evidence as to your best memory of that, if there were any discussions, and if so, what was said.
I do not recall, and I'm not sure I would have been part of those discussions.
Okay. If Nabil had come back and said, listen, we want to pursue this project under the JVA with Hexagon, please get about getting a shareholders agreement in place and negotiating with them and setting up the JV company. Would you have adhered to that request, or would have you said no?
We would have adhered to that request.
Okay. So it was still up to the commercial side of the business as to what to do.
Yes.
And you accept that, leaving aside the shareholders agreement, as you say, that's a unilateral obligation. In terms of other obligations in the in the JVA, clause 3.1, you would accept that the DIFC would have a best endeavors good faith obligation to pursue those other aspects.
I would have assumed so, yes.
Okay. Now, if we could please have a look at the letter of 12th of June. Can you remember whether it was an approach from Nabil or anybody else that triggered the drafting of this?
I don't remember.
Okay. And now, were you involved in the choice of words that were used in this letter? Was it your words or was it Sahil's?
It would have been Sohail's words, but I would have reviewed those words.
Can you remember whether you made changes or just adopted his language?
I don't recall.
Mm-hmm. Do you have any recollection of why you chose the words, "It is clear from the documents provided that we are under no obligation to continue any negotiations with you"?
I don't recall.
Mm-hmm. What about "no longer binds us" in this regard?
This is the agreement that we reached based on the passage of time, and that, you know, financial situations had changed since the agreement had been signed in 2003, and that, you know, major obligations had not been complied with.
Okay, well, let's unpack that. The major obligations, is that your reference to both parties having not complied with their major obligations over a period of time that you referred to earlier?
Well, yes, mainly, yes.
Yeah, okay. So we understand that. Then you say financial situations had changed. Whose financial situation had changed?
Not the financial crisis that had taken place.
I see. So are you saying that the DIFC had formed the view that because the financial crisis had changed the position, the DIFC wasn't prepared to continue with the project?
No, that's not what I said, and we've already covered this point.
Okay.
I said it's just that the scenario had changed, you know, from 2003, where we had, you know, certain dynamics in place, up to, you know, 2012, things had changed by then. So the financials of the deals may have also changed from what we had envisaged in 2003.
I see. And so that was, so as far as you were concerned, because the world had changed, the financial elements of the JVA were no longer current. Is that the position?
Yeah, I mean, part of the considerations, it was part of our consideration.
Mm-hmm. Were there any other considerations other than those that you've just listed?
No, no other considerations.
Okay. All right. I want to ask you about your lunch with Mr. Jawad Ali. And having seen those documents, including the invites and the calendar entry and the receipts and the handwritten note that names you, is it your evidence that you simply can't remember having the meeting, or are you suggesting that documents are fabricated and it never took place?
No, I simply can't remember having the meeting. Okay.
I mean, I speak for myself, but I find Mr. Ali a person you could never forget. I mean, he's 6'2". I was quite enthusiastic, very bright and charming. You simply sure you can't remember having a meeting with him about this project?
Absolutely. I just can't remember. I mean, I can't. If I remembered, I would have said I would have no issue, because end of the day, whether I had lunch with him or not is not really going to fundamentally change the facts of the situation that happened. So why would I not say that I had lunch with him? I just simply can't remember.
I quite agree, and I'm not being critical of you. I'm surprised you don't remember him, but I'm not being critical of you. We'll put it this way then. So your evidence is it may have happened, I just can't remember.
Correct.
Okay, fair enough. Now, and I'm sorry to keep coming back to this, but your qualifications, you say you're a UAE qualified lawyer.
So I am a UAE national, and in the UAE, for me to be able to practice as a legal advisor, I just need a law degree.
Okay. Well, that's why I was confused. So you're not registered as a lawyer anywhere in England or in the UAE on the role of solicitors or barristers, but you've got an English law degree and you're a UAE national.
Yes.
Okay, understood. My lord, subject to checking with my colleagues, I think we're there.
Okay, please check.
Yes, my lord, no further questions. Thank you.
Any re-examination?
No, my lord.
Thank you very much.
Thank you, Your Honor. Thank you.
Those are all the questions for you. You're free to go. Thank you.
Thank you so much. Thank you.
My lord, there'll just be a short break while we get Mr. Visser in situ.
Yes.
Apologies for the delay, my lord. The witness is just joining. Oh, you have Mr. Visser.
Yes, could he be sworn in or affirmed as the case may be?
Good evening, Mr. Visser. Can you please state your full name?
John Visser.
Could you please confirm if you'll be taking an oath or affirmation?
I'll take the affirmation.
Thank you. Can you please repeat after me? I solemnly declare and affirm
I solemnly declare and affirm
that the evidence I shall give will be the whole truth
that the evidence that I shall give will be the whole truth
and nothing but the truth.
and nothing but the truth.
Thank you.
Mr. Visser, we'll come to your witness statements in a moment, but first of all, can I just confirm there ought to be a solicitor in the room, Sophia Kafour Camps, is that correct?
That's correct.
And I'm sure you understand this, but she's there to help you find documents and not to help you answer questions. Could you confirm that?
I confirm that.
Thank you. And Mr. Visser, do you have, can you confirm there's no one else in the room?
There's no one else in the room.
Thank you. And do you have a mobile phone or any other electronic device with you?
No.
And have you brought any notes or any other documents that you've written on?
No.
Thank you. Could Mr. Visser be passed or opened up bundle D, please, to tab 10? Just let me know when you get there, Mr. Visser.
I have it in front of me.
Thank you. And do you see there your third witness statement?
Correct, I see it.
And if you turn to the final page of that tab, page 246 of the bundle, do you see there your signature?
That is correct.
And can you confirm that the contents of that statement are true to the best of your knowledge and belief?
I confirm that the contents of this statement is correct and true to the best of my knowledge and belief.
Thank you. And if you turn to the next tab, you'll see your fourth witness statement.
I have it.
And if you turn to the final page of that, do you see your signature there?
I see it.
And again, could you please confirm that that statement is true to the best of your knowledge and belief?
I confirm this statement is true to the best of my knowledge and belief.
Thank you, Mr. Visser. There'll be some questions for you.
Mr. Visser, is it fair to describe you as the architect of the DIFC's defence to this claim?
I wouldn't say that. I'm one of the participants in the events that took place, but you can't call me the architect.
Well, in terms of providing instructions to Gibson Dunn with respect to the defence of the claim, that's you.
I am the person in the DIFC that's been dealing with Gibson Dunn in terms of this dispute.
Okay.
Obviously, up from a particular point onwards, but in terms of Gibson Dunn, it's me.
Yes, all right. And in terms of the person who currently has either control or custody over documents relevant to this dispute held by the DIFC, that would be you ultimately.
Correct.
And in terms of making sure that people, either formally or currently with the DIFC, who might have evidence to give with respect to this case, securing them and their cooperation, would that also be down to you?
Yes. And it's in that context that we obviously contracted with a third-party services provider to make sure that it's done properly.
What do you mean by that? What do you mean done properly, and which third-party service provider?
This, in terms of the disclosure exercise, where we brought in TransPerfect to make sure that everything in relation to this matter is properly contained, on a server, and made sure that it's all there.
Okay, understood. I don't know if others are getting this, but Mr. Visser keeps freezing up.
Yes, I'm
Continue.
getting it as well, Mr. Sprange. My lord, what I'd suggest is that we plough on, and if it becomes a real issue, then we can pause and I'll try and do something about it. But I'm not sure why it's happening.
He's in the same location as the previous witness, is he? Or
Yes, my lord, correct. In fact, he's in Gibson Dunn's offices in Dubai, in the DIFC. It's an obvious reason why it's happening now, but it may just be the time of day, or I've no idea.
all right, well, let's persist. His voice was coming through clearly, but as you say, the face was frozen for a little bit. There we are. Let's carry on and see how we go.
Fine. And Mr. Visser, you are the DIFC's party representative for these proceedings.
That's correct.
And so you've been present for your sins from the first moment all the way up till now as an observer.
For most of the proceedings, not all of them.
Okay. And you've been present in the room with your legal team, so you've heard the questions and the answers and so on and so forth.
I did, yes.
Yeah. So we can assume that you're pretty well educated with the difference between the parties and the respective positions.
Up until 2012, I would say I wasn't party to Ms. Calaresi's evidence, so I didn't hear that.
Okay, fine. Now, am I right in assuming that you were Ms. Calaresi's direct replacement? In other words, when she left, you took her role?
There was a bit of a time gap, but I took over the role that she held before me.
Right. Did she tell you that she had some concerns as to fraud in the beginning, but had carried out an investigation, was satisfied that there was none?
I had no such instructions. I never dealt with Ms. Calaresi. She left before I joined. My briefing in terms of this matter was given by one of the senior legal advisors in the team, Mr. Mahmoud Kodabaksh.
Okay. Were you given a file or any documents or handover notes from her?
Not from her. As I said, my briefing and access to a file that was kept at that point in time was by Mr. Kodabaksh.
Okay. All right. Now, I want to ask you some questions about documents. Both of the previous witnesses were of the view that they would have emails, files, and other communications that may be relevant to their dealings with the claimants throughout their time. Why have those documents not been made available to them?
It's an interesting question. I think it's one for legal submissions. I think that the pleaded case of the claimant left those documents not relevant to this matter, and as such wasn't disclosed or compelled by a court order, and as a consequence may not be available in these proceedings. As I said, it's not for me to answer. It's a matter for legal submission.
So this view, I think that the pleaded case of the claimants left those documents not relevant. Is that a view that you have formed of your own volition?
It's not my view. That's, as I said, it's a matter for legal submission.
Do you accept, as the evidence seems to suggest, not only from the witnesses, but also from their statements, that documents certainly do exist in some shape or form for those periods?
I do accept that, yes.
Yeah. Okay. Have you personally or someone on your behalf within the DIFC reviewed those documents and checked them for relevance to the issues in this case?
I think that was left to our legal team.
Okay. You understand that a party to a dispute like this, if it wants to rely upon a document in support of its case, the approach is generally to produce that document in the proceedings or exhibit it to a statement.
And generally, I understand that, yes.
Yes. And you also understand that part of the claimant's case is that the DIFC failed to exercise best endeavours or act in good faith from essentially the inception of the current Hexagon shareholders all the way through to your letter of the 18th of October 2018.
I think the contract, I'm not gonna tell you what the claimant's case is. I think you can do that. But I would say that the contract does impose those duties on the parties.
Okay, and insofar as an issue of relevance in this case, do you accept that the DIFC's best endeavours or good faith or lack thereof is certainly an issue from around about 2006 onwards?
I don't accept that. I think it's something that precedes my time at the DIFC. I'm not going to accept what is relevant for you or not. That's your case to make.
You were very quick to tell us what you thought of the pleaded case. So you've obviously read it. Why are you ducking this very simple question as to whether you knew that good faith and best endeavours, say pre-2014, was an issue?
It's an obligation in terms of the contract. I cannot speak to how that panned out in the relationship between the parties. It's not for me to comment on.
I'm not asking you that. I'm asking you a much simpler question. There's documents from that period. You say you haven't reviewed them for relevance. You've given them to somebody else. Have you asked them to review them for relevance as to those issues, best endeavours and good faith pre-2014?
I'm sure in terms of what the pleaded case was, a very careful study was undertaken to understand what is relevant and what is not relevant, and that is what has been disclosed.
All right. So can we close it out on this score? That exercise has been undertaken. Very little, if anything, has been disclosed. Listen to the question. Very little has been disclosed. And there are documents that predate 2014 that I would have been worked on by Mr. Barazzi or Ms. Calaresi.
You're either breaking up or I'm not getting the question. Can you just repeat it, please?
So I will read you the transcript. Very little has been disclosed by way of internal communications from the DIFC pre-2014. Accept that?
I don't know. I've not done the assessment myself. I don't know in the bigger context, was little disclosed, was a lot disclosed. All that I can tell you is that an assessment was made in terms of the relevance of the pleaded case and what the parties rely on. And that is what has been disclosed.
All right. Were you present for Mr. Barazzi's evidence where he was discussing the mixed use issue?
Some of it, and not all of it. And in many cases, I was doing other stuff. I wasn't intently listening on every question and every response.
I'm disappointed that you weren't riveted by every in and out of this case, Mr. Visser, but in any event, what about Ms. Calaresi when she spoke about the file that Mr. Ferris and others had left with respect to that?
That part I heard. That's shortly before I left the room. I basically left the room to go read my witness statement in preparation of my examination now. So other than that initial few questions, which centered around the issue of the handover, shortly after that, I left the room.
Okay, fine. Well, was that file part of the information that you have provided to someone else to do a relevance analysis?
I cannot truthfully answer the question. I wasn't party to the handover. I don't know what the file contained. And it's certainly not the way that a handover took place to me. It was different. So I can't say when I first, sat down with Mr. Kodebaksh and trying to understand this matter, not if somebody said to me, and here's the file that Dean gave to Roberta. That's not how it took place. So I cannot answer your question.
All right. Well, I'll just give you one other example and tell me whether you can help me. Mr. Barazzi's evidence was pretty clear that he reported to Dr. Omar, and there's one example of that we've seen of a memo that Mr. Barazi sent to Dr. Omar, but very little other documents. Are you aware of whether those materials are incorporated within the materials that you've handed on to the team that was reviewing for relevance?
I'm not aware whether it was handed over or not.
Okay, all right. What about this? And this is particularly relevant to both your period and also the earlier periods. From about 2007, certainly 2008, there've been negotiations with Nexus as to, when I say Nexus, what I mean by that is the estate of Mr. Radape as to their interest. Why haven't documents relating to those negotiations and the ultimate agreement, why haven't they been produced as relevant to these proceedings?
I mean, other than the discussions, I think that Mr. Barazi had at some point with the family and exchange of emails and letters with Mr. Damien Tappy, the Swiss lawyer, nothing was ever agreed with the Radape family. So I cannot answer to, what should have been disclosed or not in the context of these proceedings relating to Nexus on that point.
Okay, you gave the name of a Swiss lawyer. Could you just spell it for the transcriber, please?
It's DAMAIN or IAN, Damien Tappy, TAPPY. Your Lordship, just my apologies. I recently recovered from coronavirus, so sometimes I get something in my throat. And
my Lord, I'm happy to take a break now if he wants some water, because he's still frozen for me. So.
No, it's fine. It comes and it goes, and if you take water, it just makes it worse. So I'll try and stick it out.
Just let me know if there's a problem.
My Lord, I was going to, sorry to interject, I was going to suggest perhaps that we ask Mr. Visser to log off and log back on again, because he has now been frozen for some time, and I don't know whether that will improve things, but it's possible. It depends how important it is to you, my Lord, to see his face in a non-frozen way.
Well,
I'd certainly like to see it, just so I know when he's struggling with his symptoms.
Well, would you like to just sign out for a moment, Mr. Visser, and then sign back in the hope that it improves the quality of the video?
My Lord, I'm being updated. Apparently, there's no actual problem with the internet connection, which is why we're not freezing. There may be a problem with the laptop, and it's got to be rebooted. That's happening now. It might take a couple of minutes, so apologies for this. Yeah, just so you know, Mr. Stewart has gone in to the witness. Oh no, he's not. He's back again. He was going to go in and just tell them to do that.
Yeah, every Saturday.
The witness is coming in now, my lord.
All right, let's see if that works better.
Mr. Viz, welcome back. If you have a problem with the dreaded COVID cough, just raise your hand and we'll stop. I wanted to ask you about one other set of documents, and if it's helpful, if Sophia could bring up for you, please, F266. That's tab 266, or page 2156 of the F bundle, and I believe that is volume 4.
Yeah. Yes, I have
so
it in
these
front.
are, yeah, so these, just confirm for us, these are board minute meetings of DIFC investments from the 19th of June, 2016.
Yes,
And JV is you.
yes.
And here, you're informing the board that the audit committee has obtained a report in relation to Hexagon. Who published that report?
I obviously wasn't directly involved in it. It was something run by the audit committee, and I myself only ever saw a draft of it. I never saw any final report. But it's some service provider that, if I remember correctly, it's PMG or PMMG or something like that, which is a services provider that the audit committee went to.
And what when you say service provider, I mean, were they accountants? Were they private investigators?
No, it's a forensic firm that do forensic investigations.
Okay. Given that Hexagon had been given a clean bill of health after much diligence by Mr. Barazi and his team, and then by Ms. Clarisi when she came on board, why, many years after the agreement has been signed, is the audit committee obtaining a report in relation to Hexagon?
The report had nothing to do with Hexagon. It was essentially a report in relation to Margit Vatpai.
But it says here a report in relation to Hexagon. Doesn't say anything about.
As in connection with. It's I mean, if you follow the trail down that path in all of the board meetings, it's clear that I think the year before, in October, a concern was raised by the head of the audit committee, Mr. Hussain Kemsi, and that concern was specifically raised in relation to Mr. Radpai, and it was specific in relation to there was any breach of a fiduciary duty in him disclosing or not disclosing certain conflicts in relation to this transaction. So it had nothing to do with the other shareholders of Hexagon.
So does that mean if this report, pardon me, had reached a conclusion that he had breached a fiduciary duty and there was a conflict of interest, and that joint venture agreement could be voided as a result, that wouldn't have been of any interest to you? It would simply be in relation to Mr. Radapay's bad conduct. Is that your evidence?
I mean, so when the report came out, it was obviously, and as I said, I only saw a draft. It seems that there was proper conflict disclosure, so all of the documents in terms of him going back and forth disclosing this conflict was there. So the conflict issue was dealt with. I think the other thing that just came out of that particular report was that you will remember that in the 2004 amendment, in the recitals, there was specific reference made to investors that were represented by Mr. Rudpai to basically, be the investors that will provide the liquid finance, the cash, so to speak. And it seemed from that investigation, because he obviously represented at the time that those investors are essentially institutional investors, Swiss banks. Mr. Rudpai was a private banker by profession. So he represented, that these people basically ready and willing to immediately provide cash. So the issue that came out was in relation to misrepresentation, essentially. But in relation to Hexagon, it really had no bearing. It was discussed at the time, but I, very quickly told the board it's too long ago. It's not something to be considered in this context or in relation to Hexagon.
But I'm still not following. I mean, Mr. Radape, may he rest in peace, passed away at the end of 2005. Why would you be investigating him in relation to conduct with respect to the JVA, whether it be conflict of interest or misrepresentation, some 11 years later? It doesn't make any sense. What were you going to achieve by this report?
Well, I first have, I'll answer your question, but I just have to qualify it in the sense that you're asking me something why. So I need to explain the motivation of it. And it wasn't.
I'll rephrase.
Yeah, but it wasn't.
I'll rephrase the question.
Just hold on. No, let him answer the question. He's got some evidence to give.
Mr. Al-Kenzi, who's the head of the audit committee, asked.
I think the judge had a comment, so we probably should let him speak.
I was simply going to say, let Mr. Visser have his say, and then you can ask another question if you need to.
Thank you.
Carry on, Mr. Visser.
So it certainly wasn't my request. And I think, I mean, if you want to put it into context, if you wanted to understand it, at least my understanding of it, if I can put it that way, it was during that October board meeting where it was clearly indicated we're going to do this joint venture agreement. Baker McKenzie says it's valid and binding, and let's do this. And it's at that point where somebody says we're going to do this, that Mr. Kenzie, as head of the audit committee, suggested, can we just check into the Rudpai issue?
Okay, and is it a fair conclusion that he wanted to check into the Rudpai issue because if the joint venture agreement was tainted by fraud, Mr. Radapay's fraud, you could get out of any arrangements with Hexagon?
I don't agree with the assertion. You're trying to say to me that we were, looking for reasons not to do this deal. That's not the context of it. As a matter of fact, we're saying we're doing this deal, and the head of the audit committee says, "Can you just check on the conflicts issue?" It's in a completely different context.
I'm not. You don't need to be so defensive, Mr. Visser. I'm not suggesting anything.
I'm not defensive at all. I'm just trying to explain to you that.
Why don't you? You're an experienced, savvy lawyer. Do you agree that if this report had said there was a serious fraud and a serious misrepresentation when the JVA was entered into, and the conclusion was, as touched upon by Baker McKenzie, that means we could terminate this JV agreement and say that it was never in place? Are you contending that that would be a legal argument or an opportunity that the DIFC would not have taken?
It is, of course. Anyone can make a legal argument about anything. And when the issue was raised, we obviously looked at it. You know, and as you will note from, you know, some of the notes and one particular board meeting, I think it may be this one. I've not read the passage that you're referring to, but it was so long ago. It's in 2004 that for somebody to come in 2015 and try and you know, terminate a transaction on the basis of something that happened in 2004 is you know, it's a little bit late. I'm not saying it's an impossible legal argument, but in my view and what I recommend to the board is that even if there was misrepresentation of sorts, it's too long ago. It's too difficult to prove. The guy is dead. What do you do?
Okay, all right. Well, this report that you've seen in draft, it hasn't been presented by the DAFC in these proceedings, has it?
I once again, I wasn't part of the you know, the disclosure process. You know, whatever that Gibson done as our solicitors felt necessary for the purposes of these proceedings to be disclosed was disclosed. It may also be, and once again, I wasn't in this, as I said, I didn't mandate the report, whether there's any privilege over it, how it was instructed, who obtained it, on what basis. I wasn't involved.
But as we sit here today, you haven't destroyed any copies or versions of it. It's out there and it exists.
I think the last time that I looked at it, or at least parts of it, and as I said, it was a draft. I don't know if a final report was probably at this time. I've never looked at it again.
All right. Now, here it says, concluded that there was a fraud or major misrepresentation that needed to be further investigated. And again, I note your words, obtained a report in relation to Hexagon. And then he suggested this matter be discussed with the DIFC president and his approval obtained to pursue this option further. Why?
I mean, this is what Hussein Kemsi is saying. You're asking me once again as to the motivation for the question. I cannot answer it. HQ, by the way, is Mr. Hussein Kemsi.
Okay. So where it says he suggested this matter be discussed with the DIFC president, that's him, not you. So you've informed the board about the report. He said there's major fraud or misrepresentation, and he's saying it should go further.
That's the way I read.
Okay. Now, you were there in the room. You were doing the presentation. Are you saying you have no understanding and there was no discussion as to why he suggested it should go to the DIFC president?
Not that I can recall.
What, did you close your ears at that point, did you?
There's nothing to close my ears about. If the head of the audit committee says to the governor, I'm a mere presenter in the room, that this is a matter that should be reported to His Highness the President, that there was fraud and misrepresentation, then let him be. I'm not going to question him on that.
Okay, all right. Now, you then informed the board about discussions with Hexagon and the present approach, which includes removing Nexus. Were you looking to remove Nexus because of these lingering fraud issues? What was the thinking behind what you said there?
I mean, there were a number of reasons. The primary reason is that ever since, I think the last person that had contact, at least what I could make out in the files, the last person who had contact with the Radpai family was Mr. Bishabaratsi, and that was quite some time ago. It is clear that whatever their involvement was, and whatever they may or may not have had in the form of a claim or an obligation under the joint venture agreement, is so long ago that there was really no need to entertain them anymore, just from a statute of limitations perspective. And secondly, if you then get into the context where somebody says there's been some form of fraud or misrepresentation as to the nature of the investors that would have come into the joint venture agreement, the logical solution is let's just leave them out of this because they're clearly not involved anymore.
So certainly by October 2016, the date of this board meeting, using your words, no need to entertain them anymore.
I think it's June, by the way, it's not October.
Oh, my mistake. You're not going to yes, you're right, 19th of June. You're not going to entertain them anymore, and they're clearly not involved anymore. So that was a view set in stone by 2016, June.
Correct.
All right. I want to ask you, you can put that away for the time being. I want to ask you some questions about colleagues. On the formal documents that need to be prepared for cases before they go to trial, you nominated, when I say you, the DIFC, nominated Mr. Mohammed Al-Najjar and Mr. Nabil Al-Kinley. Now, Al-Kindi, my apologies for the pronunciation. It's apparent that those two were important people, director of projects and chief real estate officer during parts of this project. Why is it that they have ended up not giving evidence in this case, given that they were nominated as witnesses and appeared to have important evidence to give?
I did not make the decision who will give evidence and who not. So
Okay.
I can't really answer your question.
Who made that decision?
My solicitors.
Okay. And what about Mr. Nabil Ramadan? Do you understand why he is not a witness to these proceedings?
My lord, you obviously was not an employee at DIC since I've been there for the past 6 odd years. And I can't also recall in terms of the evidence that I've heard that he came up as a relevant witness or as a relevant party to anything. So I cannot speak to the motivation as to why he is not a witness in this matter.
Okay. I want to ask you some questions just about your understanding of the party's position post the 12th of June 2012 letter. Do you agree with this characterization from the claimant's point of view? They felt that you were wrong to renounce the contract, but reserved their right to terminate pending negotiations as to a new commercial arrangement to develop the plot. Is that a fair characterization of the claimant's position as you understood it?
You're the claimant, you know what your position was. I think my recollection, and we can go to the letter and you can point me to particular paragraphs and ask me, how do I read it? But my recollection of the letter is that it was a very firm assertion, no, you're wrong. It's not as if there's not a binding agreement. We very strongly are of the view that there's binding commitments and we want for you to perform in accordance with those commitments.
I'm not asking you to think about the contents of any letters here. I'm not asking you to agree with my characterization of the claimant's case. I want your direct evidence as to your understanding of the status quo between the parties from when you came on board. So that's the context for my question. Now my question is this: is it right to say that you thought the claimants felt you were wrong on the renunciation, reserved the right to terminate, but in the meantime they were happy to talk to the DIFC about coming up with a new commercial arrangement. Is that how you understood their position?
Once again, I mean, this is quite some time ago, and I've not looked at that letter of late. But what I recall in terms of that letter was just a very clear affirmation. There's a binding agreement, and we want for you to, you know, to perform in accordance with it. That's how I recall it. Everything else that you're adding, I can't individually recall as I sit here.
Mm-hmm. So just to be clear, I've asked you twice carefully now what you thought the status quo was. In your second answer, you say, no, they affirmed and they wanted the contract performed. So you're not talking about the 12 June letter, you're talking about a response to that letter, is that right?
The response, yes.
Yes, okay. So you thought that was an affirmation, get on with it. So what did you think was happening between the parties after that August 2012 letter, all the way up to 2018? Tell us in your words. What was the parties' respective positions?
It was very clear from at least my interpretation of that letter that the claimant was of the view that there was a binding agreement. After they basically affirmed that position, there's a little bit of a fallow period. I wasn't there. I can't individually recall. I know then that at some point, I think in 2014, in October of 2014, I know there were discussions in between that you can buy the land, but you can, you have to pay commercial rates for it. I wasn't there. That's just what I read. So in October of 2014, there's obviously a letter by one of the shareholders to Her Excellency Rima Hashimi, which sort of prompted DIFC to look at this in more detail, also obtaining a legal opinion, which then obviously told us you have a binding joint venture agreement. So that's sort of very close to the point that I become involved, that we are being told by a legal opinion, whatever has been said before, in terms of the letter that was written initially to Tanmiat by DIFC, there's a binding agreement. So that's where I basically come onto the stage. Now, to answer your question as to what did I think happened there, if you look at, there's then in July some interaction between the claimant's lawyers and representatives of the defendants, and a clear question is asked. Okay, what do you want to do? Do you want to buy the land, or do you want to do the joint venture? Okay. The claimant comes back and says, I want to do the joint venture. That's exactly the point where I basically come into the equation. So for me, everything that happens after that, up to the point of, say, in 2018, when the claimant sent, the termination letter, everything that I try to achieve in this, knowing that I have a binding relationship with these guys. I've been clearly told that. I told the board, we have a binding relationship. But everything that happened from that point onwards is essentially a commercial renegotiation in the context of what that binding agreement allows for. And it was very clear, and I think the contemporaneous documents will show that as well, is that within the context of Schedule D, paragraph 2, there was this flexibility where you could do a commercial renegotiation, and that was the departure point for me, to use that as a means to achieve a proper outcome within the context of a binding agreement.
You're on mute.
I've lost you.
My lord, that may be a good time to take a short break.
All right, we'll take a 10-minute break now. Mr. Visser, I'm sure you're aware of the rules not to talk to others about the case in the middle of your evidence. Thank you very much.
You know,
When you're ready then, please, Mr. Strange.
Thank you. Mr. Visser, by 2018, let's call it the summer of 2018, do you agree with me that the DIFC had formed the view in no uncertain terms that due to the passing of time and the change in circumstances, the JV agreement, and in particular the project envisaged by it, was no longer viable?
That is not correct.
Okay, have a look at J125. So this is DIFC letter of 6 August 2017. Look at paragraph 4.
I think, Mr. Strange,
Mr. Visser, I've got to ask you a question before you give one of your speeches.
but you just asked me a question. I was just trying to answer your question. But okay, you can ask the question.
So my question is, what I just read out to you is virtually verbatim what we see in paragraph 4. Is it your evidence, therefore, that what you said at paragraph 4 of this letter was submitted in bad faith and was not honest?
No. What I tried to preempt is you are referring to the joint venture agreement. If you look carefully at that letter, you will see that it makes reference to the project. Okay, big difference. Just because I'm saying that the project envisaged in the joint venture agreement is not viable, okay, just because I'm saying that doesn't mean that I'm saying that the joint venture agreement itself is not binding. The project, if you go back to Schedule D, always had the flexibility to vary in terms of, you know, what's the makeup of the project computations. So if I say the project is not viable, it's a completely different statement.
Well, I'm still awfully confused because you say here the project envisaged in the JV agreement is not viable and needs to be completely revisited. Hence, we propose that the parties should consider putting in place a new joint venture agreement, replacing the JV agreement. So certainly at that time, you weren't decoupling the project from the JV agreement, you were expressly coupling them. And your solution wasn't to use any of the flexibility in the original JV agreement, but to get rid of it and come with a new one. So your last answer is a complete fabrication designed to get you out of a big hole, isn't it?
Not true. I mean, I'm just trying, there were obviously a lot of assertions made there. I'm trying to answer your question. But I think the question is what you're saying is that because I asked for a replacement of the joint venture agreement, I therefore, you know, either felt that it's not binding or I'm acting in bad faith. The fact that I'm actually saying that the joint venture agreement needs replacing means that I'm actually implying it's still there.
And I want you to please take up J191.
Tab. Tab 22, okay?
Now, did you draft this letter?
I did.
Okay. This was a letter that you drafted and you sent purely as a litigation tactic, and you had no good faith belief in the suggestion that you wanted to pursue the JVA as amended when you sent this letter. That's a fair summary of events, isn't it?
No, it's not.
Okay. Well, tell me whether you agree or disagree with this. By June 2016, on your own evidence, Nexus were not to be entertained anymore and were out of the picture. So if that was the case, writing to Nexus about the JVA was a waste of time. Agree?
No, I don't agree.
Okay. In August of
Sorry, hold on. Can you just let him finish his answer, please?
I'm sorry, Mr.
Courtesy.
Montague. I'm sure he can look after himself. But if
No,
he
but
wants to say anything else, go ahead.
I don't agree.
Okay.
There's a difference, Mr. Strange and my lord, between a discussion at board level on a commercial renegotiation, okay, under the joint venture agreement, who should be included or not, okay? And at that point, the decision was made in the commercial renegotiation, we really needn't bother with Nexus. Now we are at a point where we actually do want to act strictly within the requirements of the joint venture agreement, which is still valid and binding. So because I believe the agreement is still valid and binding, and Nexus is one of the parties, of course I'm going to write to them. You cannot conflate the two and call it bad faith.
Well, thank you for giving that clarification, because I think it sinks you even further for this reason. The whole board discussion, you said, was about commercial realities and getting on with things. And commercially, Nexus just didn't matter anymore. And you said, oh, we hadn't even bothered speaking to them since Mr. Barazi. Now, this is the most crucial commercial point in time with that agreement, because you're saying, let's get on with it, let's do it. So the party you have been dealing with for 12 years commercially is Hexagon, but you don't write to them. That makes absolutely no sense, unless, of course, this was a litigation tactic. Then it makes complete sense. Would you agree with that?
No, I don't agree with it.
Okay. Well, let's
Can I once again just clarify why I say I don't agree?
Be my guest.
If you see in the run-up to this particular letter, you will see that the defendants were becoming clearly frustrated with the manner in which the claimant was conducting itself. And at this point, it formed an opinion that the claimant wasn't really serious in pursuing the joint venture. So you basically sit at the end of a particular set of events where you realize in the beginning there's a valid and binding joint venture agreement. You try in the middle to come to some sort of commercial renegotiation that works. At this point, and it was clearly explained, it was written as a means of bringing the parties back to the original joint venture agreement, and Nexus was still a party to it. That's all. No bad faith, nothing otherwise intended.
If that was your concern, oh, they weren't serious, why didn't you just terminate it? Your colleagues had sought to terminate it in 2012 when they thought the effluxion of time and it not being taken serious was the problem. Why didn't you just terminate it then? That would have been the obvious thing to do.
I think if you go back through the contemporaneous documents, you would have noticed that we were really keen on developing this plot of land. We were really keen, and towards the run-up to this particular letter, we're bending over backwards, even to the point that we were willing to consider financing for the project. So it's in that context where, it's not termination is not an option. We really wanted to do this deal.
But again, I'm utterly confused. You've just said we were really frustrated, they weren't serious. You've then said, but we were really keen, and that's why we didn't terminate. But surely if you're really keen, get rid of them and do it with somebody who is. Wouldn't that be the sensible commercial thing to do? Unless, of course, this is a mitigation tactic.
No, but on what basis would I have terminated at that point?
The same basis your colleagues did in June 2012, and a position that you were happy to live with all the way up until the 18th of October 2018.
But we all know that that position was then revisited when we obtained a legal opinion to say otherwise. So why would I go back to something which
we, Mr. Bishop? When you say we, who do you
So
mean
you're
we?
speaking over the witness again, Mr. Strange. Can I
He's
ask
a
you
big
one?
boy. He can look after himself.
No,
When you
Mr.
say we, do you mean the DIFC and the claimant, or just the DIFC?
I mean the defendants.
Okay, but of course you hadn't imparted that knowledge or that position to the claimants, had you?
Which particular knowledge or position?
Well, let's just put it simply, the Baker-McKenzie position.
I'm under no duty to disclose legal advice to somebody who I'm dealing with on a commercial renegotiation. Everything that we did from that July meeting onwards, where we called them in for a meeting and we proposed to them that you have two options. You either buy the land or you do a joint venture with us. At that point in time, it became, for us, something that we pursued. When they opted for the joint venture agreement.
Have you finished?
Yes.
Okay. Now, another reason why this is a fantasy in terms of pursuing the JV agreement or any genuine attempt in that regard is look at the paragraph that starts without prejudice. Here you're saying effectively Article 2 of the original JV agreement that required an investor to be bought in, and at this point in time had been pursued and executed and Hexagon had been bought in, you're reserving your right to challenge that. So you're effectively saying we won't accept the 2006 choice of Hexagon and the UBOs, and we will keep that as up our sleeve as something that we might rise in the future.
Yes.
Is that a fair interpretation?
I would agree with you for the simple reason that that particular condition precedent was in relation to the investor being willing and able to provide liquid finance. And in this particular context, at least in terms of my dealings, the investor could never show that it was willing and able to provide finance.
All right. Well, let's say we now understand your rationale for putting this in. But in terms of the JV agreement that was in existence on the 18th of October 2018 as amended, that condition precedent had been satisfied and Hexagon were on board, and the DIFC had been negotiating with Hexagon with regards to all manner and all facets of the project for 12 years. Do you agree with that?
That's correct.
All right. And so...
But it doesn't mean I can't reserve my rights.
Sure. But it's not a very good start for a performance letter to try and undo a complied with condition precedent and reserve all rights. It doesn't really suggest you're genuinely asking a party to pursue the joint venture agreement, does it?
I can only respond by almost every communication that we receive from the claimant's lawyers was slanted with reserving rights or trying to put some legal angle to their benefit in terms of their communication. So you have to see it in the context of those communications.
So it was tit for tat on the reservations, in other words?
No, but I mean, just go through the communications. You will see that long before this particular letter, I think probably from February onwards of 2018, you will see that in the communications of the claimant's lawyers, there's this legal slant where they're clearly preparing for something. Every single statement is made to try and manufacture a particular legal point. So it's in that context.
You said every single statement is made to try and manufacture a particular legal point. Is that the conclusion we should reach with respect to this paragraph then, where you've used the word without prejudice?
If you, this particular letter and the basis upon which it was written, okay, is it's clear that the claimant, as far as we're concerned, at least the opinion we formed after we saw what they provided to us in terms of the Lloyd HBU report, and the way that they conducted themselves in the context of their dealings with ICD, and the way that some of the communications came across. I mean, at this point, I think, you know, they one of the letters started alluding specifically to the 2012 so-called renunciation letter. So this is essentially primarily a means of bringing the claimant back to the parameters of their agreement, because they were clearly going beyond that and becoming fairly unreasonable in doing so. And it's in that context that this letter was written, to basically bring them back to the table within the context of the joint venture agreement. Okay, so that's the primary objective. And if you look at what went before this, you will understand why. But at the same time, we're clearly in a situation where, if you look from the standstill agreement, and you know, every single time that we ask for something, the response is, you know, manufactured in a way that clearly shows there's a legal slant to it. So you do sort of start.
I'm sorry to interrupt you. I think we've lost the judge. So if you could just hold on for a moment.
Sure.
Mate, I don't know if you're able to check on the judge. Tom, I don't know whether you've heard any developments as to whether somebody's looking for the judge or not. I'm just a bit worried we're all sitting here waiting without any action.
No, I haven't heard anything. I suspect that's our lot. That is our station to sit and wait.
Okay.
I'm sorry, I've had to come back on the phone because my computer ducked out, and for reasons I can't ascertain, won't reconnect. So,
My lord, do you want a minute to catch up with the transcript? My guess is we lost you for about 60 seconds before we realized.
well, I can't catch up with the transcript.
Oh, because you don't have a computer, obviously.
I've just got the phone and nothing else. I don't think I missed very much, but
no. From the claimant's perspective, I'm happy for you to read the transcript in your deliberations of the 60 seconds that you missed and just pick up, if that's okay with Mr. Montague-Smith.
Yeah, just remind me what the question was you asked.
I knew you were going to ask that. Just go. Yeah, keep going on, please. Okay, yeah. So Mr. Visser had described the claimant's communications as every single statement is made to try and manufacture a particular legal point. It's in that context. And then I asked him whether that particular paragraph in the letter was to manufacture a legal point, and he was answering that. And then that's on page 151, and then at line 15, we asked him to stop just because you appeared to have ducked out.
Okay.
So basically page 150 of the transcript when it comes to you.
All right. Well, I think my computer's about to come back on again, but let me just see. No, just carry on and I'll continue with the phone.
Thank you. Mr. Visser, is there anything else you wanted to say about that paragraph of that letter? So it's the without prejudice to its right to challenge paragraph in J191.
Not really, other than that, I think the only other reason or motivation for putting it in is that at some point later in that letter, we're actually proposing to the claimant to put in the liquid finance. And this goes back to the point of being willing and able to provide liquid finance, which was a condition precedent. So you also have to see it in that context.
Okay. My next question about this letter is as follows. You argue and contend that it was effectively withdrawing the 12 June 2012 letter. So I have two questions for you. Why isn't the 12 June 2000 letter therefore referred to in this letter?
I mean, the June 2012 letter was the furthest thing from my mind, to be honest. You know, in terms of if there was a renunciation, it was clearly confirmed afterwards. We're now a few years down the line. I'm trying to act within the constraints of the agreement itself after being frustrated by the claimant in terms of progress and having doubts of my own in terms of their good faith.
So, okay, so that's why you, as you put it, the 12 June letter was the furthest thing from your mind.
I mean, the 12 June letter, when I made reference to it now, if you look at, I mean, after the August 2017 response to the term sheet, okay, we are now trying to really make this work. We've given a definitive statement on how we see this going forward. Then you see the claimant starting to hang back on the substance of the matter. Okay, they take their time to produce a highest and best use sort of study of this particular plot. They don't provide the requisite financial information, the feasibility. We know in hindsight that they've had it, but they don't give it. Okay, So there's this, then there's this discussion with ICD where clearly they just become unreasonable. And it's in that context where you're seriously starting to doubt the faith of the other party. And it's in that context that this letter was written. And the point that I was at exactly the same time, instead of focusing on making this deal work, the only thing that the claimant does is to write letters in a particular way as to working towards trying to make a case against the defendants, I presume, for termination. It's clear that if you look at some of the language, I mean, the one that stood out for me at some point is where Mr. Jawad Ali said something. It's clear that we were always intended by the joint venture agreement and never sought any other. From, I think, 2010 onwards, is to impose new conditions on this agreement up to 2018. It's like these slanted statements that clearly, to me, was not an indication of good faith.
All right. Mr. Visser, I don't mind you giving these long speeches in support of your case. It's totally up to you, but I do invite you just to listen to my question.
Sure.
And answer that, because we're on an inquiry here to decide some complex legal issues, and you restating again and again the IFC's case it isn't going to help anyone. Everyone's aware of it. We've been in this room together for a long time now.
My apologies. You started with this line of questioning. My apologies. I don't want to talk over. But you started with this line of questioning to try and say that I was acting in bad faith. And it was actually the opposite.
Okay. All right. Now, going back to your choice to send this to the Swiss solicitor, Mr. Damien Tappy from Nexus Capital. Now, Mr. Radape had been deceased for 13 years at the time of this letter, correct?
I don't know exactly when he died, but yes, more or less.
And the only communications that had taken place with Nexus on behalf of the DIFC were with the representatives of his estate, Mr. Tappy, to try and reach a settlement in relation to their interests, correct?
I think it's also, if you go back to the amended joint venture agreement, it was the notice details. So it went to whatever the joint venture agreement stated to be the notice details.
Mm-hmm. But can you answer my question?
What is your question again?
That is why I suggested to you good-heartedly that you listen to them. So the only communications that had taken place with Nexus on behalf of the DIFC since his passing were effectively negotiations with the estate to resolve any settlement as to the Nexus interest, correct?
I mean, in fairness, I think probably 2 or 3 times in my time at the IFC, and I think one of those or maybe 2 of those came actually after your client, purporting to terminate. But Mr. Tappy did send, the odd letter asking, where are we at? But because we took that view in the earlier board meeting, I think we may have responded to one of them, but in the last 2, we didn't even respond.
To your knowledge, did anyone on the commercial side within the DIFC have any discussions with Mr. Tappy or other representatives of Nexus with regards to the following: the GFA, the BUA, the concept design, or the mix?
Not that I'm aware of.
Mm-hmm. Did anybody on behalf of the DIFC have any discussions with Mr. Tappy or anyone else from Nexus Capital regarding the total project capital?
Not that I'm aware of.
Okay. You understand that under the joint venture agreement, the total project capital is basically the entire capex for the project.
I would presume so. I mean, I need to go back to Schedule E.
J4. J4. Have a look at J4.
I can only agree with you, but it makes sense. I just need to look at it. It's not J4 in our bundle, unfortunately, my lord.
So Sophia knows this document's in a few places. I'm looking at the core bundle J4, but it's also in the F bundle. So if you go to there, total project capital means the total capital required by the JV company to undertake the development of the project, exclusive of the purchase price for the project land. Agree?
I agree.
All right. Now, further evidence of why this was a tactical letter sent for tactical purposes and wasn't a good faith attempt to comply with obligations under the joint venture agreement is that you did not have in your head, as at 10 October 2018, a set number for what the total project capital was, did you?
Other than the computations in Schedule E, no set number whatsoever.
Which at that point were 14 years old.
Correct.
Okay. The second point is this, that the joint venture agreement at Schedule D, paragraph 6, it's very clear that the investor shall be required to invest the total project capital in the joint venture company by way of liquid finance, brackets, close brackets, in return for its proportion of the shares in the joint venture company. So you would never ask for the total project capital up front until such time as the shareholders agreement had been concluded and the JV company had been incorporated, and there could be a share swap by way of capital contribution of the total project capital. That's how it was envisaged, wasn't it?
I think when that particular clause was drafted, it was meant as cash.
Mm-hmm. Well, Mr. Visser, you're a lawyer. You've purported to write a letter where you're seeking performance in good faith and using best endeavors of a joint venture agreement. And I'm just perplexed as to why you didn't put a number for total project capital. You didn't say, here's the shareholders agreement, here's the JV company shares, as per 6 on J16, Schedule D, in return for TPC of X million, we'll give you these shares. Why didn't you do that? Why didn't you follow that course?
Can we just go back to the letter, please? Because, the way that it worked is sort of obviously the first thing that needed to take place under the joint venture agreement was to settle the shareholders agreement. The party that was responsible for the settling of the shareholders agreement was Nexus. Okay. If you look at all of the other things that you've referred to, and the request for the to put in liquid finance, that was offered, by the way, when Mr. Al-Ramaizan wrote to Her Excellency Rima Al-Hashmi. He offered that, said we're ready to put in the required capital. Okay, so and if you go back to what was always the problem in all of this, if you think about it carefully, is the claimant's unwillingness to put in the capital. So here is just a proposal. Can you please put in the liquid capital? Just to bring them back to the basics of the agreement. I don't know if you asked the question or whether you're on mute.
I just wanted to see if you'd finished your evidence on that question.
I have.
Yeah, you said claimant's unwillingness to put in the capital. You didn't send this request to the claimant. You sent it to the widow of Mr. Radapay's representative. Did you sincerely, honestly, and genuinely believe that Nexus Capital and Mr. Damien Tappy were going to contribute millions and millions of dollars by way of project capital to this project when you sent this letter?
Well, we obviously also copied Hexagon on it. The simple reason why they don't feature in the heading, and we just sent it to them because it was obviously intended to get for them to act in accordance with this, is that what I had at that point, when all of the scanned copies, this was a double-sided document, and for one reason, that last page, which is of the joint venture agreement, the amendment, that was on the last page where they added the notice details of Hexagon, and for some reason, the copy that I had on file, whoever produced that electronic copy, did not scan the last page. So it was always clearly intended for Hexagon. I just had Nexus and their notice details, and at the same time we sent it to Hexagon.
Okay. Now this last sentence of the last paragraph on the first page, given that Hexagon Cayman is required under the agreement to invest by way of liquid finance, the total project capital in the joint venture company, DIFC proposes that such liquid finance be provided within 3 months from the date of this letter. Now, that was an absurd suggestion, given the language of paragraph 6 of Schedule D to the joint venture agreement, because the provision of the total project capital, both the amount and the timing of it and its form, were all things that were supposed to be negotiated and agreed and put into the shareholders agreement. You accept that?
This takes us back to the original agreement. Okay, there's a clear statement in the joint venture agreement and the amendment what that amount is. I'm taking you back to that, and I propose, as you offered when Mr. Ramazan wrote to Her Excellency Riyam Al-Hashimi, we were ready to put in the capital. I'm just taking you back to that agreement and say, I propose, I mean, it's yes, the agreement also then says this is something to be agreed, but it's a proposal. I'm waiting for you to come back and say, okay, this is how I'm going to do it.
Okay, could you look at J16? Let's just have a look at D6, please. So it's J16, this is paragraph 6. We've already been through the TPC is in return for the shares. And then says, the shareholders agreement shall fully enunciate the arrangements for the investment of liquid finance by the investor, so as to ensure the timely availability of funds to undertake the construction and completion of the project within the deadline referred to in paragraph 4 of Schedule C. Then there's the aspect about the TPC not being borrowed by the JV company. And then it says, save has said additional capital requirements of the JV company from time to time shall be met in a manner resolved by the shareholders. So isn't it clear from that you've got this entirely back to front at the end of your letter? What you should have been doing is submitting, using best endeavors, using good faith, with this letter on the 10th of October 2018, a proposed shareholders agreement, the JV company with its shares, and said, please send us the amount of X as a proportion of the TPC in return for your shares, and then distribute funds as proposed in this shareholders agreement. That would have been a good faith, best endeavors way of seeking performance of the JV agreement, wouldn't it?
So let's start with the back end of the assertion on good faith, best endeavors. I'm not sure whether I'm under a duty, in terms of best endeavors, in the context of performance, under the original AJVA. I'm basically in a situation where it's clear at that point, if you look at all of the correspondence that preceded this and all of the discussions, it's becoming very clear that the claimant does not want to put any money into this project. It's basically trying to trade itself out of a position where it's lost money, paid to a third party, and is now trying to recoup that. And in that context, it's clear that the one thing that they do not want to do is to put in liquid finance. At the same time, when we started this path, it was offered. So it's proposed, put it in. The fact that the parties then need to agree on the modalities of it and how it will take place is then expected to be that will flow from this letter. That is how it was intended, and that is, you know, the basis upon which it was sent.
So do you mean you weren't saying give us all of the money necessary for this project in 3 months? You were saying we want all the money for this project, but let's negotiate a shareholders agreement which can set out the modalities, as you say, as to how that should happen. Is that what you really meant to say in this letter?
What I meant to say is that you have an obligation under the amended joint venture agreement to provide liquid cash. I'm asking you for that. The fact that we then need to discuss on how that will be given and when in terms of project cash flows is a separate discussion. And yes, that can then ultimately be agreed upon in the shareholders agreement.
Thank you, Mr. Visser. No more questions from the claimant.
Re-examination?
No re-examination, my lord.
Thank you very much, Mr. Visser. Those are all the questions, and you're free to go.
Thank you, my lord.
Well. We now have two of you, my lord.
Yes. Okay. Right. I don't quite know what happened, but I managed to get back on in the computer in the end. Anyway, there we are. Experts tomorrow.
Yep.
Yes, my lord.
Very good. Well, let's see how we go, shall we? Anything else need to be dealt with now?
Nothing from
No,
me, my
my
lord.
lord, I guess the only thing I was going to say is that at some point tomorrow, it'd probably be good to confirm where we're going to be, whether we're doing closings on Monday or Tuesday.
Yes. Well, a little bit. We've discussed this before, but my views may have changed a bit. It would help me to have references to such parts of the evidence that you rely on, and I don't need that beforehand necessarily, but to have it in writing would be helpful, whether in the form of a speaking note or simply a list of references or whatever. Insofar as, I mean, obviously I've got the documents in any event, and all parties have always agreed that actually the documents are very important in this context. Whether parties are taking a different view having heard the evidence, I don't know, but again, it would help me to know the extent to which you say the evidence that I've heard impacts on the documentary record as it is. And
Well, Lord, I don't know if this is helpful as an indication, but what we had intended to do was to give you references to the key parts of the evidence by way of topic. For example,
yes,
there is an issue relating to the BUA, and there's probably 20 documents. To give you a chronological list. With that list of the BUA documents, we were just going to drop the transcript references in so you could see where the witnesses. Yeah. So, and for us, there's probably 7 or 8 topics. So we would give you the reference to all of those. And during the closing, we would invite you to make particular findings about each topic and then bring them together. So that's certainly what we were intending to do.
Yeah.
If that's along the lines of what you had in mind, we'll press on.
well, that seems to me to make sense. But it's going to be a slightly longer document than the one we discussed earlier, I think.
Unfortunately.
Yes. From our side, my lord, we'd anticipate something similar, albeit by reference perhaps to breaches rather than topics. And you may have an inkling as to why I put it in those terms, because at present, as it stands at present, the case is rather spread over a very long period of time, and quite frankly, it's not entirely clear precisely what it is said that my clients should have done but didn't do, did but shouldn't have done, a case that we've been trying to extract for some time. Now, obviously, I can devise some of that from the cross-examination that was put, and so things like GFA and BUA and so forth. But if we were to have some sort of list of topics in advance from my learned friend, that might assist.
My lord, I always do as I'm told, and you've asked for all of the references, and certainly I'll be speaking first. So we'll get it around to you and Mr. Montague-Smith as soon as humanly possible. Without becoming extremely unpopular with all of the real hard workers around me, I'd rather not give an estimate for that, a time estimate for that just yet.
Well, a bit depends on when you finish the experts. Are you each handling the experts yourself, or are you delegating to somebody else?
Mr. Williams will be presenting Mr. Williamson, and I'll be cross-examining Mr. Broad.
Right. Okay.
Yes, it'll all be in my hands, my lord.
And is there any likelihood that we'd get through both of them tomorrow?
From my side, my lord, as I said, my best estimate at the moment is 3 hours, 3 to 3.5.
Yes, 3 to 4. You were saying earlier. Yes,
Something
so we're
like that.
unlikely then probably to get through in a day, but we could be through by lunchtime, or the equivalent of lunchtime, so to speak, on Thursday. Is that right? Is that how you see it, Mr. Sprain?
Yeah, I'd be disappointed if we haven't finished by Thursday. And if Mr. Montague-Smith is only 3 hours yesterday, there is a possibility, I put it no higher than that, that I could be done in 2 hours tomorrow. So that's why I'm confident about Thursday lunchtime.
Right. Okay. Well, let's revisit it then as to when you want to do your closings. But it's Monday or Tuesday, and it probably doesn't make a lot of difference to me which it is, as long as giving you more time doesn't encourage you to be prolix and verbose.
Well noted. The only other point I had to raise on all of this, and this is somewhat controversial, so I just raise it now, so it can not necessarily be debated today. I may wish to, I don't know whether I've got this right or I need to apply for it, but we may want 45 minutes in reply to Mr. Montague-Smith. We may not, but I just flag it now.
Well, my ordinary practice is that claimant gets the last word.
Well, it rather depends on whether we've had a chance to answer everything that's been put, my lord, because it sounds like we're going to hear some new things in closing. But there we are. If one takes it from the cross, my lord, I don't object in principle. If anything new comes up in response, it may be that I'll ask 15 minutes after.
If new matters turn up, then I'll give parties the opportunity to deal with them. But we've got a pleaded case. as I understand it, the pleaded case has changed to this extent, that now whatever happened after 2012, the so-called renunciation letter, is all by way of WP negotiations towards settlement, which means that most of that really doesn't feature, save insofar as it suggested it's evidence of bad faith. If I've misunderstood Mr. Strange's case, no doubt he'll say so. But as I indicated when I think we had last had a discussion on the subject, it appears to me the case turns essentially on what occurred between 2006 and 2012. Am I on the wrong track, Mr. Strange?
No, obviously the question of the renunciation and whether the right to terminate was survives all the way through to 2018 remained an issue. But in dividing in terms of breach and preservation of the renunciation right to terminate, yes.
Yes, I mean, on the assumption that you've reserved your right to terminate, your termination in the end depends upon the breaches that occur prior to 2012.
I would say, including 2012. I wouldn't exclude 2012.
No. But I mean up to the date of the exchange of letters in June, July, August, September.
Exactly. Yes, that's correct.
Yes. No, I'm not. I'm not excluding the letter itself. I understand that as part of your case, but that's the way that I've understood it. And in terms of where the BUA, GFA, and user mix feature, they are said to be illustrative of a bad faith intention to delay in the context of the pleaded breaches in clause 18 of failure to execute the various documents, incorporate joint venture company, and so on. Have I understood that right?
Yes, I would add lack of best endeavours as well as good faith.
I follow that. The fundamental issue that I would like the parties to be thinking about and to deal with is, I think, essentially this. The provision is that the parties are to, in good faith, use their best endeavours to execute a shareholders' agreement. To my mind, that's the key to the whole future of the joint venture project. I mean, no point in incorporating a company unless you've got a shareholders' agreement, you've got percentages worked out, you've got articles of association, you've got share capital, and so on and so forth sorted out. Basic principle of English law, which I understand essentially to be the position in the DIFC, agreements to agree are unenforceable. So the question is, what exactly does the clause 3.1 duty, as amended in the AJVA, actually mean in the context of seeking to execute, by which inevitably it means agree, a shareholders' agreement? That seems to me to be an absolutely fundamental question, and I'd like to know quite what's being said. Is this going to be said to be an agreement to negotiate in good faith? And if so, is it an agreement to negotiate reasonably, or what? I mean, it's absolutely fundamental to this case what that duty encapsulates. And I don't know if the parties are producing authorities on it. I haven't yet looked, I'm afraid, at the authorities bundle to see what there is on either best endeavours or best endeavours in good faith, and particularly in the context of what looks like, first blush, an agreement to agree. So I need help on that.
Yes, understood, and it's certainly at the forefront of our minds, and you will be getting additional authorities on those points.
All right.
From us, and I'm sure.
Do you wish to, without in any way committing yourself to a proposition, do you wish to encapsulate in a couple of sentences what you say the duty really does amount to?
I was about to, and then I got devil looks from several of my colleagues. So
I
think
know,
that
but
means
I'm putting you under pressure to do so because I need to have some idea which way this goes, particularly if, as I anticipate, I'm going to reread the chronological bundle, or at least those parts that are relevant, in the light of what the parties say the other was bound or bound not to do.
Yes, understood. Well, I'm still getting those dirty looks, so I am going to shut up.
All right,
because they're next to me, my lord, and you're on screen. But your indication is well received, well understood.
I would like to know that before we stop and prepare closing speeches. So you can go away and think about it and put it down in writing so that all those who are giving you dirty looks are happy with whatever it is that you say.
Yes.
I don't want to tie you down specifically at this stage, but I do require you to be tied down at some point, and before we get closing speeches.
That's very fair and
the same
accepted.
Same point for Mr. Montague Smith. I want to know exactly what he says it involves.
Well, my lord, on that, I mean, I did answer this question for you in opening, and I'll just summarise again what our primary position is in relation to this. So our primary position is that the duty is in good faith with best endeavours to execute a document which clearly on the terms of the agreement was to be produced by a third party. And it's in that context that you have to consider the content of the duty or of the defendants and whether that can genuinely be to agree something or to draft something or to take concrete steps. That's the starting point. But the ending point is, we say that even if one takes this despite one's nose argument to mean that, in a sense, the computations were up for grabs, there's no realistic way in which that can extend to the commercial terms, particularly in relation to financing. And as to that,
I understand that. I mean, it seems to me absolutely self-evident that whatever the clause involves, the starting point is the HAVA, and where there are gaps in it, then, as with many, I'm not going to use the word heads of terms, but in basic agreements that the detail hasn't been sorted out, then the details fall to be agreed and aren't perhaps restricted by the terms of the HAVA itself. But where the HAVA itself makes provision for either amendment, revision, or does not, then that's where you start from. And once you get outside that framework for other things that may require agreement that aren't specified in any way, and in that context, maybe the user mix comes into that. Maybe it does, maybe it doesn't. The question then is, where does one go? Agreement to agree?
Yeah, exactly. And you're right.
Agree, then it's no good. But on the other hand, if you've got a best endeavours clause of this kind, what sense do you make of that in that sort of context of filling the gaps, if I can put it that way?
Yes, I see.
I've laid that all out so you can have a think about it and let me know what your submissions are in relation to each head, as to which is and which is not covered in the HAVA, what is a gap, and what is in fact ruled in or out by the principles that are set out in the HAVA for revision. None of this would matter very much if one wasn't looking at a position years and years and years later, one suspects. But the other view that I've taken so far on the evidence, which I can be persuaded out of, is that the world had changed in a very significant way between 2004, 2005 and 2012, which is probably the relevant point for current purposes. What impact that has? Again, that's a matter for submission. But I don't regard the view taken in 2012 by the DIFC as being completely unsustainable. Passage of time made this very difficult. And did it mean that actually there had to be some revision that was contrary to the terms that were set out in the AJBA if the project were to go ahead? And if so, what's the impact on that on the parties' obligations?
Understood.
And on
I'm
that,
sure they're all
on that
matters.
final-
I'm sure they're matters
And
you
on
would have thought about long ago, but I need them laid out for my simple mind, please.
And on that last point, my lord, the passage of time point and the revision and the impact on the obligations there, you're particularly interested on what does a best endeavours obligation and a good faith obligation do when circumstances change?
Yes, well, obviously it comes up in that context. You know, you've got
Okay.
the obligations, and everybody's accepting that the joint venture agreements, as it was in the AJBA, persisted. But what does it really mean? That's the question. And it
Yes.
may come to a point where what you've got essentially is an agreement to agree in different circumstances that doesn't go anywhere. It's a possibility. And really, as I understand it, that's pretty much the view that the DIFCA formed in 2012. Reflection of time meant, you know, none of this works anymore, particularly as the parties haven't adhered to the original obligations, which were to do things with as soon as reasonably practicable or whatever. It all looks a bit different, doesn't it? Anyway, there we are. Give me your convictions. I have doubts enough of my own, as Voltaire is supposed to have said. But better still, just give me your submissions rather than your convictions.
Understood, and thank you very much for the observations. They're always helpful.
Well, thank you. All right. Usual time tomorrow then, please. Thank you very much.
Thank you.